Supplementary list, pronouncement of judgment, item number 1.
Yes, perusal of pleadings and the materials have been placed for consideration, however, do not contain any details, historical or otherwise, to establish irrefutably the contention that the markets in question were established by Nohma themselves. The list of markets appended to writ petition is also not a document that has been generated by the petitioner to show the markets established in Nohmas of the respective Akhangs, but only a list of names and markets which has been issued by the respondent themselves and appended to the tender notice dated so-and-so inviting bids for collection. In the absence of any cogent material where even the locus to maintain the petition has not been substantiated, especially in a matter where challenge has been made to the various of regulation, it is indeed difficult for this court to ascertain any infirmity as alleged. More so, the source of power, legislative competence of the District Council clearly defined the schedule itself. It is important to note that when a challenge is made as to constitutionality of an act or regulation, as an instant case, wherein the powers vested on constitutional authority such as the Council are clearly delineated in the 6th schedule to the Constitution of India, the same should raise questions that strike at the root of legislative competency of the Council, especially taking into account the fact that the Council does not possess plenary powers of legislation, but as observed earlier is confined to subjects mentioned in 6th schedule itself. In instant petition, what is projected is about a general grievance without no materials on a specific harm that's being caused. Further, there are no assertions or pleadings as to the violation or restriction of any fundamental right, the unreasonableness of the legislation, or has there been any clear articulation of the grounds of challenge or a presentation of any relevant evidence in support of the claims of British society. The British Association, no doubt, may be an association of traditional heads or recognized Nohmas holding office. However, in the presentation of the matter before this court, in question authorities of the Council to collect tax or toll have visibly failed in fact to address the issue before them, which in the opinion of the court is more of an issue that concerns the manner of implementation rather than the constitutional validity of the Garo Hills or so and so. According to the petition, the facts themselves being bereft of substantial material is untenable and dismissed. Okay.
Any mention?
May I please, Your Lordship? Yes. I beg to mention item number 13.
Number?
13. 1-3, my Lord.
1-3?
Yes, my Lord.
Criminal appeal?
Yes, my Lord. So I'm seeking...
No objection, Your Lordship.
After?
After 3 weeks, my Lord.
3 weeks?
Yes, my Lord.
Okay, 3 weeks.
Pablo, Your Lordship.
May I please, Your Lordship?
Yes.
Lordship, I would like to mention item number 11, Lordship. In this matter, Lordship, pleadings are complete, Lordship.
Is in the hearing list?
Yes. Yes, Lordship. Taking counsel from the other side, Lordship. Lordship, may kindly adjourn this matter for 4 weeks.
For today?
Lordship. 4 weeks, Lordship.
4 weeks? 3 weeks, okay. Yes, 3 weeks. Yes.
Much obliged, Lordship.
On the prayer of the petitioner, yes. Yes, Ms. Kohli.
My Lord, item number 9, my Lord. This matter has gone ex parte as per Lordship's last order. My Lord, the Council has requested, my Lord, he has given me a call. So I can see, sir.
No, you can't. You have to put an application for setting aside the ex parte hearing.
My Lord, I will do the needful, my Lord, but today...
No mentioning, we will take it up because he's here. That application should have been here on record.
He has just given me a call, my Lord, last night. So... if Lordship can
kindly... Just by a call, he can set aside the order.
No, my Lord, the reason which he has given me was, my Lord, quite a... I feel, my Lord, that I should address this court, my Lord, because of that of the sister and the manner in which she has died, my Lord.
He's come ready for the matter.
The manner his sister has passed away was quite unfortunate, my Lord, which is why he was...
That's why he appeared.
Because he was not... My Lord, true, my Lord. Because I was not able to contact him. He was not contacting me, so I decided that if the clients and the council which has not informed, then it was not possible for me to continue. But then the reason for which was quite unfortunate, my Lord.
Only today has made an impassioned plea.
My Lord.
to allow the respondent to put an application to set aside the order ex parte.
My lord.
Let me say S.C. Kayal, who's here, who's present on behalf of the appellant, does not have the objection. Accordingly, prayer is allowed.
My lord.
List after 2 weeks, yes, for the orders.
Lots.
Yes.
Daily list item number 1.
But in this case, notice was issued from line defendant as appearing for respondents. On last occasion, he raised some preliminary objection. Probably
What objection do you have, Mr.
Well, it's two issues I'd pointed out. One was, Millets, that under the
Petition.
Act, it has to be filed within a certain period, Millets. It has not been filed. We were just examining the records, Millets. As a matter of fact, what I'd pointed out before my lords is the impugned order, which my lords would find at page 22, Annexure C.
Yes.
Millets, this order was, date of pronouncement is 14/8/2024, my lords would see.
Yes.
Now, if I had also pointed out, Millets, page 29. My lords, have page 29.
29?
At serial number 3, my lords, copies marked to the PR CIT Shillong.
Yes.
So, my lords, the inference has to be that the order was communicated to them at that point of time.
Yes.
Now,
14
this,
August 2024.
my lords, now this appeal before this honorable court,
Filed in June,
my lords,
27 June.
correct. That is my preliminary objection, my lords, and I pointed out, my lords, section 260A, capital A, my lords. My lords have it. Okay, my lords, kindly have a look at subsection 2, my lords.
Second to see if I get the end. Yes.
Well,
Appeal to
it's
High Court.
the principal appeals to High Court. Well, it's subsection 2. The principal chief commissioner or the chief commissioner or the principal commissioner or an SSC aggrieved by an order passed by the appellate tribunal may file an appeal to the High
120
Court.
days.
120 days. So it is way beyond 120 days. So, well, it's the period of limitation would come into play. That's one. Now, what has happened, Melody, what we've just seen from the records.
You also mentioned that the principal commissioner has already received the copy.
That's what I.
The order was marked to him.
It is already marked to him, Melody.
Yes.
And that is the copy that's annexed in the file of this honorable court.
Yes.
That's not my copy, Melody. It's what they have annexed. So, my lords, in page 1, what they have done is, if my lords kindly have the cause title.
Yes.
My lords, an appeal under section 260A of the Income Tax Act as against so and so, my lords. Judgment received on by hand is written, my lords, 28/2/2025.
Yes.
That's only for the purposes of, my lords, getting past that appeal. Now, Annexure C, my lords, where that is annexed, if that paragraph, my lords, I may just point out. At paragraph 4.
What's the pleading?
Paragraph 4, my lords.
Yes. Yes.
That being aggrieved by the aforesaid order, the SSC respondent preferred an appeal before the ITAT Guwahati briefly so and so, the Honorable ITAT Guwahati held in its considered opinion that the IT had no authority to assess the income of the SSC respondent. The TO has violated CTBT instructions dated so and so by the assessing officer and having no jurisdiction to do in the instant case. Therefore, the Honorable ITAT set aside the order passed by so and so, delegated so and so, as well as the assessment order dated so and so passed by the assessing officer. It is not the case of the appellant before my lords that the order was passed in well, it's August, and communicated to them only in February 2025. In the absence of any specific averment, this appeal is not maintainable in its present form.
They have not made any pleading.
Nothing.
Anywhere in
There is nothing, Malaj. Somebody, assuming, Malaj, we would have to take that benefit if there is an averment supported by an affidavit or otherwise, Malaj, saying that order was passed in August, but we received it on so-and-so date. That doesn't seem to be the case. Prima facie, Malaj, it is communicated to the CIT. That is the copy which is annexed as Annexure C. And, Malaj, to get past the embargo under Section 260 capital A2, what they have done is, Malaj, they've simply written a date which basically conforms to the period of limitation.
Yes, Mr. Gal, what is your reply?
Lordship, Section 260A says that the date when the order was received, that from that limitations to be calculated. And it,
No, but only one thing, Mr. Gal, only his submission, if he is submitting that is well and good. But the thing is that there are no materials given in your appeal to establish that fact that order might have been passed on 14 August 2024, yes, but came to your knowledge on so date, and received by your office on so attended to you by so and so date. So that's sufficient. Is a sufficient cause only.
In cost title we have date has been given. Yes, Lordship, that is correct. No amendment is made. Yes. Lordship, allow me, I'll upload this record, Lordship.
Or you put in a small application?
Yes, Lord. For my learned friend can raise the objection by filing a affidavit. So it will be better to...
maintainability.
Yes, I think you better put the objection in.
We'll put a formal objection.
Yes,
I'll put a formal
objection.
Of records only.
Whatever they want, they can put their writing. So we can able to...
The other aspect is, if I may, even if they bring anything by way of an affidavit at this stage, would not be curable, Malaj. I'm not in...
Put an objection, let him file, and it depends on the court.
Yes, Lord.
Your Lordship will then decide the matter.
Yes. Mr. K. Paul Lennis, Senior Counsel, assisted by Mr. S. Banda, has raised questions of the admissibility of the instant appeal on the ground that the same is beyond the period of limitation allowed by the Act. Stop. He prays that we are allowed to put the objection on affidavit. Mr. S. E. Kyle, appellant, prays on the affidavit being served, prays for 1 week's time to file objection.
Yeah, after filing is within a week, Lord, you will file our.
I missed that. On receipt of the said affidavit or objection, the reply will be filed within a week. So, accordingly, this is the matter after 3 weeks. For the order.
Obliged.
Item number 2.
Yes. Am I audible?
What is the matter?
Well, we are required to file an affidavit.
What's the matter about Dr. Mozika?
This is a customs appeal, my lord. There is a application for continuation of delay of 8,500 some days, my lord.
8,000?
Almost.
That's all.
8,567, my lord.
2001 order.
That's a 25 years delay, my lord.
Yes.
Well, I'm required to file an objection. I'm praying for some.
There was no appearance last time, and now briefly, I think some counsels appeared and vanished. Yes, we'll record again. Where's the local counsel?
It seems there is no.
To put an objection, yes, though none appears for the appellant or for the appellant. Stop. In the interest of justice, let the matter stand out after 2 weeks. the learned DSCI is allowed to file an objection in the meanwhile. Yes.
Item number 4.
Special bench. Yes. What else are we?
My lord, this is a case relates to SBI capital gain deposit scheme.
There's a new
Earlier, your order was there 6/9/24, page 26.
6924.
6/9/24. Direction was there to pass the final order, but they passed the partial order.
What's the difference in partial order and 69?
6/9/24.
There's no order 6924 here.
Page 22.
Page
You
26.
mentioned the page.
Page 26 in my petition.
Yes.
So, 8, paragraph 8. My lord?
What page?
Page 26 of read petition.
Page 26 is just a
Order
part of
of
the order.
Order of this honorable court.
Oh, it starts on 22.
Yes.
Yes, page, that is relevant page. Relevant page. Starts from 22.
Yes. What does it say?
Paragraph 8. Accordingly, it is directed that on production by the petitioner before the respondent authorities of all material necessary to be taken into consideration on the application for closure of CDG's account, the respondent shall thereafter within a period of 4 weeks decide the matter and pass the final order, my lord.
Yes.
So thereafter they have passed the final partial order 122/11/24.
Where is that?
That is page 82 to 89. Relevant page 89.
Yes, 20.
To 89, relevant page. 4. The submission of the SSC is neither in accordance with
second.
CGH
Out of
1980.
court to come to the page at least. Effect of the normal High Court order of Meghalaya dated. Okay.
Yes, my lord. So, the submission of the SSC is neither in accordance with CGAS 1988 nor as per provision of IT Act 1961. However, in view of the judgment of the Honorable Meghalaya High Court 6/9/24 in passed in WPC 213/24, the effect to the said order as per para 8 of the order is being given in consideration of the submission along with relevant documents of the SSC, which is in accordance with the provisions of laid down in the CGAS Rule 1988 and the Income Tax Act 1961, subject to the withholding of capital gain tax to the tune of 27,32,400. That is 20% of the sale process.
Yeah.
Now, from the above mentioned CGA's account is hereby approved. They have approved 1,09,29,600. I received the amount. But balance amount 27,32,400 and interest 28 lakh 11,500, total 55.43 lakhs is balance. So I pray that they should pass the final order.
They've held back your capital gains tax as all.
No, that tax, but they cannot retain the tax on future tax liabilities. They are.
Yes, Mr. Kaya.
We file affidavit and Lordship thereafter, Lordship, page 90.
Oh, yeah, affidavit.
No, read petition, Lordship.
90, yeah.
Lordship, page 95.
Yes.
Paragraph 4, last paragraph 4. Effect of the Honorable.
This is the same that is read just now, correct?
That is
And Lordship, we file affidavit.
that is fair
everything.
type copy and original copy.
We file affidavit. Lordship may come to our affidavit page.
Page.
Lordship, paragraph 8, Lordship.
Paragraph 8 is just four
Lordship,
lines.
no, Lordship 9.
9.
Married Lordship.
Yes.
That with regard to the averment made in paragraph 7 of the writ petition, the answering respondent state that the SCC petitioner has reiterated the same issue which has already been discussed in preceding paras and hence no comments. However, the compliance of all the conditions as claimed by the SCC petitioner, which includes the filing of the revised income tax return for the assessment year 2089, it may be pertinent to mention that the compliance by way of income tax return for the relevant assessment year is completely a separate issue, does not form any part of the closure of CGST proceedings. The SCC petitioner was requested to file return of income for the assessment year 2018-19 by way of issuing notice under section 148 of the Act. Since the SCC petitioner has not disclosed the immovable property transaction in ITR, which was required to be filed as per provision of section 139(1) of the Act, even if there is a loss occurred on account of transfer of capital asset, accordingly it may be concluded that non-filing of the income tax return for the relevant assessment year on plea of the SCC petitioner sustained a loss on sale of immovable property is not according with the income tax law. So he has not filed any.
Even by the returns at all.
No, my lord, since there was a loss, I did not file.
Why?
But then, my lord, when they have directed to file, I have filed on 3/9/24, page 81. Yes, this.
The revised has been.
Yes.
You file a revised.
Yes, I have filed.
Then?
After the page 81, my lord.
You're running around circles. Yes.
No.
81. Revised return has been filed on 3/9/24.
What happened to that? What happened?
That is pending. That is pending for the last 9 months, more than 9 months. Though I am not required to file, but since they said I am to file, I filed immediately. And now it is another more than 9 months.
Why do you say it's not required to file?
Because there is a loss. So it is not required to file because under section.
Where does the law say that if you can't file, you need to file return if there's a loss?
My lord, since there was a loss, I have not filed. But when they have said that I am to file, I have filed. At page 81 on 3/9/24.
So we'll close this matter.
Yeah, no, they should pass the final order, appellable order. Whatever they have passed the partial order. I cannot go to the appellate authority.
6/9. He said
so they should pass the order.
Return was filed on 3/9, but this honorable court passed order on 6/9/24.
Yes, after that only. When you have intimidated, then only I have filed.
You address the court, not me.
Yes.
Then in paragraph 11 further we have made clarification, Lordship.
They cannot keep it pending for indefinite period. It is already 8 years.
By your own conduct, why the delay has been caused?
No, it is for their conduct.
Please try to understand. Filing is mandatory. If you have not complied with it, whether loss or profit, with paragraph 11 what he said. Yes.
Lordship, please choose paragraph 11, Lordship, of the affidavit. That with regard to the amendments made in paragraph 10 of the writ petition, the esteemed respondent has no comments to offer. However, it is matter of fact that the pursuant of the direction given at para 8 and 9 of the order dated 6/9/24 passed by this honorable court, the closure proceeding of CGDS account was initiated by the providing an opportunity to the SCC petitioner for hearing along with supporting documents. In response to the authorities, the representative of the SCC petitioner attended the hearing on 8/11/24 and 11/11/24 respectively with relevant details. During the closure proceeding, the AR of the SCC petitioner offered comments of the queries raised. In this context, it may kindly be noted that the AR of the SCC petitioner commented against the deposit of sale proceed of CGDS account even if there is loss or transfer of capital assets. It was a mistake due to wrong advice by the tax consultant. Furthermore, it may also be kindly be noted that while asking the AR of the SCC petitioner as to why the due tax on account of capital gain should not be levied on the unutilized amount of the sale proceed deposited in CDST account, since as per the provision of the Act, the SCC petitioner failed to utilize the amount so deposited in CDST account wholly or partly by purchasing or constituting a new capital assets within the specified time, which expires in present case on 27/2020. The SCC petitioner commented that it is humbly submitted that any due tax would be paid in accordance with law. Loss income tax return was not filed as the loss was not included in the capital carried forward. The AR of the SCC petitioner knowingly with careful avoided the specific provision of law and did not make any comment on it. In addition to the above, the AR of the SCC petitioner agreed to the proceeding proposed withholding of the capital gain tax at the time of hearing the above closure proceeding. After being discussed with AR of the SCC petitioner vis-a-vis the considering the submission made as per the provision of law, compliance of the direction of Honorable High Court of Meghalaya has been made by way of passing a final speaking order dated 21/11/24 requesting the banking authority to release a sum of rupees 1,09,20,000 so and so out of rupees so and so.
Yes, Mr. Dasgupta, what you've come for by that order has been complied with. What has happened subsequent, if what you have submitted before the authorities is correct by authorized representative, then what's there for the court to do now?
My lord, balance amount is there. 55 lakhs.
That
is if I am to pay.
That came out later.
Not later, my lord. This is the deposit from my deposit.
You never disclosed it in the first instance. So how can there be a full adjudication of the matter?
It is my only prayer to decide the issue, to pass the applicable order or final order. As you have. Yes. They should pass the order. Yes. If I am to pay tax, I will pay tax. I will pay tax, my lord. But they cannot retain it for indefinite period. In the event that collateral, they are keeping it collateral for future tax. That is not legal, my lord. Yes, that is my submission. They have to find the. They have to pass the order, final order, applicable order. I will be satisfied. I can go to the appellate authority. If I am to pay tax, I will pay tax. That is my only submission.
Unless they disclose the entire facts.
I have already discussed everything. It is already submitted, my lord.
Now, when did you submit your revised income tax return?
3/9/24, page 81. Revised income tax return was submitted as.
Matter was taken up by this court.
No, as per earlier order, this is the third round litigation. That is as per 21/3/24 order.
21/3. That order?
That is at.
Next.
Yes, I have annexed. Annexure 1, probably.
Annexure 1 is epic card.
Yes, this is annexure 2.
This is dated.
First order was 21/3/24. Second order was 6/9/24, and now
this order, this one, this proceeding 1 to 27 is dated 7/3/24.
Yes, my lord. Yes, this is for transfer of my PAN. During the pendency of the CDGS account, they have transferred my PAN from here to there. from Calcutta.
The next order, 21-324, what does it say?
They said that they should give me an opportunity.
Where is that?
Annexure 2, my lord.
Yes, Annexure 3,
Annexure
19.
3, page 19.
Where which thing of submission, the peer respondent is concerned, 2.5, shall produce all the evidence and so on.
So as per order 21-324 of this honorable court, the department has asked me to file the return. I have filed at page 81. And thereafter also now more than 9 months, no order was passed on the reassessment proceeding.
Before whom now is the matter pending?
In the ITO 2, Work 2.
They have not been issued in
No, my lord. When it was a final state discussion is going on and all the, then they have transferred it to Calcutta. Because of...
Yes, Mr. Kyle.
Lordship.
What is your suggestion?
Lordship, as per my instruction, they have to file.
End his grievance, yes.
They have to file reverse return. That will be decided within a 15 days.
It's already been filed.
He has already filed. Let take page 21.
Lordship, pleased to see. He said that it was filed on 3/9.
Yes.
Thereafter, on 6/9, order was passed.
So after a subsequent you file.
No. Before
can you file revise?
after the first order, my lord. 21-324.
Please listen. Can he file it now? He'll have to file physically now. He can't upload it into the portal anymore.
No, Lordship, he file in physical mode.
You can file physical mode.
Yes.
No, already I filed. I can file again physical mode, no problem.
You file physical mode because
okay, my lord. Okay, I'll file.
The submissions, you understand what submissions have been made. Is that this entire adjustment now will have to be after the order of that is the order of 24/11.
24.
Sorry, 24. Correct.
Yes, Lord.
There's the last order passed. We said it's not final disposal. Where's the order? Impugn order?
Impugn order 6/9/24.
No.
That order is page 22/11/24. 82. Page 82.
Yes.
82 to 89.
So then you have heard a submission. Do you file it?
I already filed. I'll file.
Then we'll close it.
Yes.
Then which is time frame, my lord? Can we fix a time frame so that yes.
After his filing return, Lordship, within 30 days.
I have already filed, but I will again file it physically.
Yes.
Allow physical filing returns. Otherwise, there'll be issues again.
Yes, Lord.
You say you can't upload. He'll come again to court.
No, Lordship, the direction may be given. Lordship, authority will act as per the order of this honorable court.
Whose authority is to do the
Lordship,
directive?
here.
You just kindly give the correct one. Respondent or
Lordship, Income Tax Department, Office of the Income Tax, Calcutta, Lordship.
ITO was
Respondent number 3.
It's what is the
ITO? Income Tax Officer, Calcutta, 52.
So the first revised return you file on 3/9.
Yes. As per direction of the online, they have said that in pursuant of the order dated 21/3/24 of this.
Yes.
Lordship.
Much obliged.
Yes.
Item number 6.
In terms of the last order, respondents were supposed to file their affidavit, counter affidavit, Lordship.
Your Lordship, we're still awaiting instructions from the department, Your Lordship. Therefore,
How much time have you sought till date?
this will be a third time,
When was the
Lordship.
matter filed?
Lordship, the matter was moved on
18th.
24th, Lordship, 24/6/25.
24th, 25. Or give them one more portion.
Lordship.
Yes, MSK Guru principal allowed how much time?
3 weeks' time, Your Lordship.
Next time to file affidavit. Just thereafter.
Lordship, item number 7 is also connected.
Connected,
Also, is together with WC 249 2025 the next day. Yes.
Much obliged, Lordship.
Hearing. Hearing item number 8.
Your Lordship, if this matter may be taken up at the end of the vote, Your Lordship.
Mr. Sinkon is here. This is Lulita Rapini.
What is If I can start, my lord, it will take some time.
Yes, you start.
Yes, my lord.
Where are the hearings? How many then? We'll take it the last hearing.
My lord.
10 and 12. 10 and 12.
We'll take it last hearing. Follow the other matters first.
Item number 10. Item number 10.
Lordship, this is an appeal from single bench, Lordship.
Where's your opponent?
Lordship, I think Sujit
Yes.
Dehi is appeal.
He's somewhere
Why are you
here.
looking out there?
He's outside here.
He's outside. Then call him inside.
Lordship,
Yes.
in this case also I'll take some time, Lordship, because I have to go according to the
Where you have to go?
Lordship, the judgment passed. After the judgments, what are the provisions for appeal? I have to take Lordship's attentions to some of the judgments passed by Honorable Supreme Court in other cases also, where
Have you
it
made a compilation?
no,
Have you
Lordship.
given the list of books?
At least I'll the soft copy of the judgments are with me, Lordship. I'll supply the soft copy during the course of hearing, Lordship. Lordship,
Anyway, then you prepare the compilation. How long you'll take, you said?
Lordship, it will take approximately, Lordship, half an hour, Lordship, to start with my hearing, Lordship.
To start the hearing half an hour.
It means like to conclude my hearing, Lordship.
Mr. D, ready?
Yes, yes, ma'am.
Ship.
You were ready with the matter today, but
Yes,
soft
yes,
copy
I am
won't
ready,
do.
Lordship.
You have to give. Have you given list of books to the
Lordship,
court
I
master?
have the soft copy of the judgment.
Have you given list of books?
No, Lordship. Lordship, because I already have the soft copy of the judgments.
No,
It means
you
hard
have
copy of the judgment.
Citations.
Citations, I have the copy of the citations. I'll duly provide. I have the copy of the citations. I have taken out the printout of the.
Oh, that's good.
Lordship, I'll take Lordships to the first to the summon issued, Lordship. Page number 145, Lordship. Summon.
1 second. MSP, I think we would, since we in a partner matter, I
Lordship.
think we will post it.
Then we can do like this, let her give the book list. I will also go through.
You supply the book list also.
Then we can go through and then
The next day you come prepared. Because otherwise we are in a. It's quite a longish partner matter.
Lordship.
Let us supply me a copy.
The request of the council. This is up to 2 weeks. Okay.
My lord.
Lordship.
Hello.
Hello, please.
Item number 12.
Lord, this matter, my lord, I have a small prayer, my lord. There is one identical matter, my lord, WPC number 131 of 25, and this matter will have a bearing on that matter also.
131.
WPC number 131 of 2025, my lord. Similar matter, my lord, in fact. I was just praying, my lord, if both the matters could be tagged together, my lord.
What is the name of the parties?
Here the question is, Lordship, we asked them to file return. They said that we are exempted. Lordship, unless they file affidavit, their return, it will be difficult for the authority to come to a conclusion whether he is entitled to.
But that is something that your lordship will have to decide. The other matter also, my lord.
Oh, you mean to say that now your stand will be that you don't have to file returns at all?
We are exempted. We are saying that
Exempted means what?
Filing returns.
You can take it otherwise. But then if now with the new regime that's in place, how they assess tax and how they can tap your accounts and all. That's the only thing whether
well, here the only problem, my lord, we were not even afforded an opportunity to show cause also. That was an issue. In fact, in the other writ petition also, it is the issue is similar. We were not even afforded to file our show cause. And I mean, the time span given was too.
Other matter, you are appearing that matter.
Too lesser time.
Who's appearing that matter? Mr. Pandey?
No, Mr. Chetia is appearing, my lord. I think he is also.
Chetia is on the panel.
Yes, he's a senior standing counsel.
I was just praying out since the issue are identical in both the
What's
matters.
the name of the parties there?
It is Remington G. Momin versus Union of India.
Remington Momin?
Yes, G. Momin, no?
The other matter. Yeah.
WPC number 131. No?
Not that Mitchell Wankar or something.
No.
You are appearing there also?
No. It is slated to be listed on 26/8, man. The other petition.
Maybe technical lordship, we have no objection.
Yes. When the matter is taken up, Mr. S. Thapa, the counsel for the petitioner, submitted that the subject matter issue in the present petition is similar and identical to the matter in relation to WPC number 131 of 2025, which is pending hearing before this court. He prays that the matters may be heard together. Yes. Mr. S.E. Kaya Leonard, counsel for the respondent, has no objection. So according list the instant matter together with 131 on the next date. Yes.
No.
On the next date fixes.
All right.
Much.
Item number 8.
You're for the petitioner, Dr. Mursi, or no? Who's for the petitioner? Oh yes, Mr. Ghosh, right.
My lord, in the earlier matter, my lord, there is an interim, my lord. I'm sorry. I forgot.
Yes.
But this matter is for reply by the responsible.
But reply, no, that's what, reply by whom? You first, Syncon first, or whom?
But lordship permits, state can reply, my lord, I'll reply on the, if time permits today or on the next statement.
No, let Syncon start then. Mr. Syncon, you start. That issue is very small. I don't know why the
in
hearing
fact, my lord,
so
matter is not so simple as it seems. Lord,
simple
there
as
are
it
many aspects, my lord, which are involved in this case.
Simplify matters.
My lord, I'll try, my lord.
And the duty of the counsel is to assist the court to simplify the matter. Yes. Therefore, respondent number 2 and 7.
Yes, my lord, I'm for the ERTS department. Here, my lord, the entire case, my lord, of the petitioner, it revolves around the power and function of 3 authorities, my lord.
1 second. Today's date is 5th. Yes.
My lord, the entire case of the petitioner, my lord, it revolves around powers and function of 3 authorities, my lord. One is the CBIC, second is the GST Council, and the third is the central government, my lord. Now, as far as, my lord, the first authority, that is CBIC, CBIC is a creation of a statute, my lord. I have given a compilation at page number 3.
This is the only compilation?
My lord, but this is the only compilation, my lord. I tried to
because you
bring all
understand that
those.
the petitioner, he submitted eight volumes of compilation.
But the documents that mostly I am relying, my lord, I have tried to compile so that we do not have to go from one document to another.
Right, I don't want to jump from one to their compilation to your compilation.
That's why, my lord. So, my lord, as far as CBIC is concerned, my lord, CBIC is a creation of a statute, that is the Central Board of Revenue Act 1963. That is at page number 1 of my compilation, my lord.
Yes.
This is the Central Board of Revenue Act 1963, and the relevant portion is at page number 3, section 3, my lord.
Yes.
Now this section 3, it says constitution of separate central boards for direct taxes and for indirect taxes and custom. The central government shall, in place of the Central Board of Revenue, constitute two separate boards of revenue to be called the Central Board of Direct Taxes and the Central Board of Indirect Taxes and Custom. And each such board shall, subject to the control of the central government, exercise such powers and perform such duties as may be entrusted to that board by the central government or by under any law. My lord, mere reading of this provision, one thing it makes it clear that these two board, one is Central Board of Direct Tax, that is CBDT, and the other is Central Board of Indirect Tax and Custom, that is CBIC. These two boards are created by the central government by exercising power under section 3 of the 1963 Act. Now, my lord, this section also says that these two boards shall be subject to the control of the central government and shall exercise such powers and perform such duties as may be entrusted to that board by the central government. Now here, these two boards are the extension of the central government when it comes to direct taxes and indirect taxes. When it is a matter of direct tax, CBDT comes into play. When it is a matter of indirect taxation, my lord, CBIC comes into play. So these two boards are the extension of the government, and what these two boards can do can also be done by the central government, because these two boards exercises power from the central government, and therefore whatever these two boards can do can also be done by the central government.
So your definition of control is that it has absolute control.
Absolute control, my lord.
See, as each board shall control the central government and be entrusted to that board.
Yes.
That means there's no autonomy in the part of the board. What is entrusted to them that they can
do, and
within their limitations.
Right. Whatever has been entrusted to them by the central government, that whatever function and duties will be entrusted by the central government, they will perform that part of the duties, my lord. And they are directly under the control of the central government. It is already there in section 3, and they will discharge such duties and perform such actions, my lord, which are entrusted to them by the central government. Therefore, they are just a mere extension of the government when it comes to direct taxation and indirect taxation. And these two boards are created, my lord.
That's information.
Now, yes. Now, my lord, second authority is the CBIC. Second authority is the GST Council. My lord, before rolling out of GST, the central government has brought the Constitution 101st Amendment Act 2016, that is at page number 5. If my lord will come to page number 5 of my compilation. And relevant page is at page number 7, my lord. The government has brought the constitutional amendment, and then they have inserted Article 279A in the Constitution, that is at page number 7. It says the President shall, within 60 days from the date of commencement of the Constitution, 101st Amendment Act 2016, by order constitute a council to be called the Goods and Service Tax Council. And clause 4, it says the Goods and Service Tax Council shall make the recommendation to the Union and the states on the subjects which are enumerated, my lord, in subclause 4, my lord. And then, my lord, by section 14, page number 8, it has also inserted Article 366, page number 8. it says 12A was inserted. It says goods and service tax means any tax on supply of goods or services or both except taxes on the supply of alcoholic liquor for human consumption. Now these two articles were added in the constitution, and thereafter, my lord, if my lord will come to the next page, page number 11.
Okay, just go slowly.
My lord.
You have lots of time. 11 is?
Page number 11, Annexure 3.
Yes, that is the what order is this?
Now, my lord, after the constitution was amended and article 279 and 366 was inserted, thereafter, my lord, the president has constituted the GST council, that is at page number 12. Wide notification dated 15 September 2016. So since then, GST council is in operation, my lord.
This is under Article 279.
Yes, my lord. And as far as the third authority is concerned, that is the central government. The central government, my lord, derives power from the constitution itself, my lord. If my lord has a copy of the constitution, my lord will see Article 268A. It says, service tax levied by union and collected and appropriated by the union and the state. Taxes on services shall be levied by the government of India, and such tax shall be collected and appropriated by the government of India and the states in the manner provided in clause so and so. And also Article 270, my lord, it says taxes levied and distributed between union and states. All taxes and duties referred to in the union list except the duties and taxes referred to in Article 268, 268, 269 respectively, surcharges on taxes and duties referred to in Article 271 and any cess levied for specific purpose under any law made by the Parliament shall be levied and collected by the government of India and shall be distributed between union and the states in manner provided in clause
268 and A and
268A and Article 270. So this is the source of power where the central government is deriving power as far as levying of tax is concerned. Now, my lord, coming back to the present case, my lord, the fact of the present case is that, my lord, the NHA has issued a tender for construction of road of about 61 kilometers in the National Highway 40 from Jorabat to Shillong. If my lord will see page number 13 of my compilation, this is the tender notice, my lord, which was floated by NHA, page number 13. Now it says, my lord, paragraph 1, the National Highway Authority of India invites applications for the pre-qualifications from applicants interested in design, engineering, construction, development, finance, operation and maintenance for 4-laning of Jorabat-Shillong section of National Highway 40 from kilometers so and so to 61 by 800 in the state of Assam and Meghalaya to be executed as bought annuity project under SARDP and these are scheme, my lord. Now, after this, my lord, after this tender was floated by NHAI, various bids were received by the NHAI, and thereafter, my lord, the NHAI has shortlisted few of the bidders, including the consortium comprising of ILFS Transportation Network Limited and RAMK Infrastructure Limited, my lord. Now, after evaluation of the bid, my lord, NHAI has issued the letter of acceptance to the consortium and has requested them to ask them to sign the concession agreement.
What date was this NIT floated?
NIT, my lord, the date is not here in this tender notice, my lord. However, at paragraph 9, page number 14, it says RFQ submissions must be received not later than so and so 23rd January 2009.
Okay.
Now, after, my lord, the NHA has issued the letter of acceptance to the consortium and asked them to sign the concession agreement. What the consortium did is, my lord, it did not go ahead and sign the concession agreement directly. What it did, my lord, it has incorporated a separate company by the name JSEL. Jorabat Shillong Expressway Limited, incorporated and promoted by the consortium. And after incorporation of this new entity, my lord, it has requested, the consortium has requested the NHAI that let this new entity sign the concession agreement on our behalf, who will execute all the work in the project on our behalf. Similar request was also made on behalf of the JSL to the NHAI, and ultimately, my lord, NHAI has allowed the JSEL to sign the concession agreement, and concession agreement was signed for construction of this stretch of road on a bought annuity basis, my lord. Now here, my lord, it becomes important that what is the difference between bought annuity and bought toll model, my lord.
Yes.
This is the crux of the case, my lord. Right, my lord. Now here, bought toll, as my lord is aware, bought means build, operate, transfer. They build the project, operate during the concession period is there, and after the end of the concession period, they transfer it back to the authorities, my lord. And in lieu of the taking up the project, my lord, the concessionaire is paid in terms of toll. Here, the concessionaire has the right to collect the toll. So in one way, they are in the business of giving access to the road. If suppose somebody denies to pay the toll amount, toll charges, the concessionaire has the right to refuse access to such person. Now here, my lord, in this model, my lord, BOT toll, what happens is the concessionaire is the service provider. He provides the service, he supplies the service, and the user of the road, they are the recipient of the service, my lord. And therefore, for uses of the road, my lord, they pays in terms of toll charges, which is collected by the service provider, that is the concessionaire, my lord. Now, my lord, what happened when it comes to toll, the government did not want, my lord, that extra charges should be levied on as a GST in toll amount, because road is usually used by all sections of people. So they wanted that there should be an exemption on toll so that people are not overburdened. Now here, my lord, comes the notification number 12 of 2017, that is at page number 38.
Yes.
This is the notification, my lord. It says
Which 30th, 28th June.
28th June, my lord.
You said 12/11.
My lord, the notification number is notification number 12 2017,
okay.
And date is 28th June 2017, my lord. Here in this highlighted portion, my lord, it says the central government, on being satisfied that it is necessary in the public interest so to do, on the recommendation of the council, hereby exempts intrastate supply of services of descriptions as specified in column 3 of the table below. Now relevant page is, my lord, page number 44.
Yes.
Here, serial number 23, it says service by way of access to a road or a bridge on payment of toll charges. On payment of toll charges, this is being exempted, and whoever is entitled to get this exemption, they must be in the service of, they must be in the business of supplying such service by way of access to a road or a bridge on payment of toll charges. So the control for the access of the road must be there so that they can have the benefit of this exemption, my lord. Now when it comes to, my lord,
annuity,
bought annuity,
yes,
is the same way billed.
Do you mean to say that this Jorabat Expressway is by annuity?
This is by annuity, my lord. This is
then why is the toll barrage there then?
Let me clarify this aspect. But here what happened, my lord, National Highway has, like the district council does, my lord, they tender for per annum, my lord, they've done like that.
So to pay the annuity to the
But for example,
So just let us try to understand. Now this the bill operator transfers annuity and there's tolls, right? Now you see under heading 9967, then tolls is exempted. If it's a toll access to a bridge, so on.
I'll give this explanation. My lord.
Now its annuity is not.
Yes, that is
the distinction that is.
My lord, I will
Why? Yes, Dr. Mazika.
what happened, my lord? This toll gate, this highway is the property of National Highway.
Yes.
Highway Authority of India. Toll gate is not operated by Shillong-Jorabat Expressway.
Okay.
What National Highway has done, they tender periodically, and once any company or individual, they pay a lump sum amount to National Highway Authority, and they collect. Like the district council.
Yes. They engage third party to collect the toll amount.
So that amount in turn becomes annuity payable to them.
Exactly.
Payable to the petitioner.
Payable to the
petitioner. Lump sum maybe 100 crore per year, 200 crore per year from the contractor, and that money National Highway pays to Shillong-Jorabat.
And what about the maintenance?
Maintenance, my lord, as far as
how many years is the, how many years as per the NIT now, as per your
31 till 2031, my lord.
We hand it over to NHI again.
Yes. Now the very basic difference is, my lord, in both annuity, what happens? They build the project, operate during the concession period, maintains it, and then transfer it back at the end of the concession period. In the earlier model, my lord, BOT toll, instead of for taking up this entire project, they are allowed to collect the toll, and that is their consideration. But in BOT annuity model, my lord, what happens? They do the same work, but they are not allowed to collect the toll. Here, instead, NHAI gives them on deferred payment, that is annuity basis, in a year, that is here, my lord, is 2 times. So that is the fixed amount. That
what is the amount here you being?
Here 71 crores or something, my lord, in 6 months period. So NHAI gives them the fixed amount for a particular duration, my lord, that is up till 2031, if I am not wrong. Now, in this type of model, my lord, NHAI, where do they recover the money? They have to collect. Here, the concessionaire is not collecting the toll, but NHAI has to make the payment. Therefore, they will engage another third party, my lord, to collect the toll, and they are paid on annuity basis or some other arrangement, whatever, between these two parties, my lord. Now here, my lord, the basic difference is, my lord, when the NHAI appoints the third party to collect the toll, NHAI can give on annuity basis on deferred payment. This is the fixed amount. So it is only in that context, here the third party is engaged in the supply of service by of giving access to the road. The same work they are doing, like BOT toll, my lord. And therefore, they are entitled for the exemption because toll has already been exempted in the earlier model, my lord, by the notification. Therefore, the need arises that even the annuity which they are receiving for taking up the collection work, my lord, that also be exempted. That is the context how in the by the subsequent notification entry 23A was inserted, my lord, and thereafter exemption was made for service by access to road or bridge on payment of annuity. That is in that context, my lord.
Pay of toll.
Right. No, my lord. Subsequently, even for annuity, notifications was brought in, my lord, and then earlier exemption notification was amended to some extent, my lord. That my lord may kindly come to page number 65, my lord. Page number 65, my lord. This is notification number 32 of 2017, dated 13th October 2017, my lord. Here it says, on the recommendation of the council, hereby makes the central government, on the recommendation of the council, hereby makes the following further amendment in the notification of the Government of India in the Ministry of Finance, number 12 2017, that is the earlier exemption notification. And my lord may kindly come to page number 66, the relevant insertion, my lord, that is in the table 23A. Yes, 23A.
They made it clear again.
Yes, here they have inserted service by access to a road or a bridge on payment of annuity. So now,
enlarge the scope.
Yes, both toll and annuity are at par.
Yes.
Only in that context, whoever is engaged in the service of giving access to the road.
In that context.
Only in that context.
But if you're what do you call it, construction company?
No, my lord.
It will not be.
It will not. I will explain why, my lord.
Yes.
Now, in this model, my lord, BOT annuity, here also the concessionaire is the service provider, whereas the recipient of the service is the NHAI. In this model, recipient of the service is the NHAI because construction was made on behalf of the NHAI. They are the receiver of the service. In both cases, my lord, the service provider remains the same, but the recipient of the service are different. In one case, it is the user of the road who pays the toll charges. Toll charges was exempted, so user of the road are not required to pay the GST on top of the toll charges. Whereas in annuity model, my lord, the service provider remains the concessionaire and recipient of the service is the NHAI, my lord, on whose behalf the construction was made, my lord. Now here, my lord, it is an admitted fact by the writ petitioner, my lord, that they are more than construction. What they have said, they are into construction. They maintain the road, they repair the road, they operate it during this concession period. At the end of the concession period, my lord, they transfer it back to the authorities, my lord. Now, if my lord will see section 2119 CGST Act, my lord. Whatever work, my lord, they are doing, section 2119. It gives the definition of work contract. Whatever the petitioner is doing, my lord, that is covered under this definition, my lord.
Work contract.
Yes, work contract, my lord. Now, it says, my lord, work contract means a contract for building, construction, fabrication, completion, erection, installation, fitting out, improvement, modification, repair, maintenance, renovation, alteration, or commissioning of any immovable property wherein transfer of property in goods is involved in the execution of such contract. Whatever kind of work the writ petitioner is doing, that is covered under definition of work contract. They are supplying the services of work contract, my lord, and it is an admitted fact by the writ petitioner, page number 468. My lord may kindly record page number 468 of the writ petition. Relevant page is 473, paragraph 5.6.
What did he say?
Here, my lord, they have admitted that the JSEL made the composite service of development, maintenance and operation. Composite service, my lord, when the service provider not only gives one type of services, it provides various type of services. If my lord will come to page number section 8 of the CGST Act, my lord, it describes what is composite supply. And how in cases of tax liability, in cases of composite supply, how tax liability is determined, my lord.
What is this 8B? It's very confusing.
My lord, I'll come to it, my lord. I'll explain, I'll try to give proper explanation for all this composite supply and mixed supply, my lord. Section 8 says, my lord, tax liability on composite supply, composite and mixed supplies. These are two different. Now, my lord, tax liability on a composite or mixed supply shall be determined in the following manner, namely, a composite supply comprising two or more supplies, one of which is a principal supply, shall be treated as a supply of such principal supply. Mixed supply.
So they forget about the smaller supply.
There is a way how to levy the tax, my lord. A mixed supply comprising two or more supplies shall be treated as a supply of that particular supply which attracts the highest rate of tax. In composite supply, what happens, my lord?
The bigger of the big quantity, they, at that rate they're taxed.
My lord, in composite supply, my lord, all type of supply will not come into composite supply, my lord. Now, to come into the definition of composite supply, it has to be naturally bundled. Now, if my lord will see the explanation that is given,
Very confusing.
it is very confusing little bit, my lord.
The definition is very confusing. See, a composite supply, fine. Composite means multiple, comprising two or more supplies, one of which is a principal
My lord,
supply.
it has been beautifully explained, my lord, in the
Judgment.
my lord, I have given a write-up, my lord, just for the purpose of understanding what is the difference between these two, my lord.
Composite and mixed supply.
Page number 142, my lord.
It's your beautiful explanation.
My lord, it has given explanation how the
140 of your
142, my lord.
yes.
Here it says why parameters of
mobile and charger.
my lord. It says
Where's 142?
my lord, may kindly come to the next page, 143. It says the composite supply, my lord. Clause A of section 8 defines composite supply. A composite supply comprises of two or more supplies, one of which is a principal supply, shall be treated as a supply of such principal supply. Interpretation: composite supply means a supply made by a taxable person to a recipient, comprises two or more taxable supplies of goods or services or both, or any combination thereof, which are naturally bundled and supplied in conjunction with each other in the ordinary course of business, one of which is a principal supply. Principal supply means the supply of goods or services which constitutes the predominant element of a composite supply and to which any other forming part of that composite supply is ancillary supply. Here example, my lord.
Phone and charger.
My lord, in the same page, the right side, my lord, example 1.
Yes.
It says ABC Limited manufacturer entered into a contract with XYZ Limited for supply of ready-made shirts packed in design boxes at XYZ Limited's outlet for a consolidated price of 10 lakhs. Further, ABC manufacturer would also get them insured during transit. In this case, supply of goods, packing material, transport and insurance is a composite supply wherein supply of goods is a principal supply. Here, the main supply without which this ancillary supply will not come into picture. Now, in this case, my lord, the main supply is the supply of the shirt. That is the goods. If without the supply of the goods, the question of insurance of that goods, the question of packing material, those supplies will not come into picture. And therefore, the supply of goods, that is the shirt, that is the principal supply. And in cases of composite supply, my lord, it is the principal supply which will determine the tax liability, my lord. There may be various tax for different ancillary supply, but those are not counted. What will be counted is what is the rate of tax for the main supply, that is the principal supply. Here, in our present case, my lord, the writ petitioner, admittedly, they are into construction. That is the main supply, my lord, that is the principal supply. Whereas the other, my lord, that is they are maintaining the road, repairing the road, or doing all other activities, my lord, they may attract different rate of tax, but those are not counted. For the purpose of levying tax, my lord, it is the principal supply in cases of composite supply which is which determines that will determine what is the rate of tax. Now here, if we see the tender notice also, my lord, the project cost around 536 crores, my lord. That is one supply. My lord, may kindly see again the page number 13.
Certainly. Yes.
Page number 13, my lord. When the NHA floated the tender, my lord, it has given one tender for the design, engineering, construction, development, finance, operation, maintenance, and the cost that is in the table, my lord, around 536 crores, my lord. Now, there was no separate amount for which has been paid to them for for doing different tasks, my lord. This is one supply, that is the composite supply, and the construction part will determine, that is the principal supply, this will determine the tax liability of the petitioner, my lord. Whereas in mixed supply, what happens, my lord?
What's mixed supply?
Mixed supply is, my lord, they can supply various items together, but these items may carry different rate of tax. However, these items are not naturally bundled. Not naturally bundled, like in cases of gift pack, my lord, sweets. If suppose they have added cold drinks along with the pack, my lord, the cold drinks probably is the highest rate of tax. So, in cases of mixed supply, the highest rate of tax will determine the entire levy of tax, my lord.
Yes.
So that is the basic difference, my lord, between these two, my lord. Now, if my lord will come to page number 15, my lord may kindly see what is the rate of tax that is applicable for composite supply. Page number 15. Notification number 11 of 2017, my lord.
9%.
Page number 15. Here, my lord, serial number 3, that is the construction service under heading 9954. Then the Roman 2, my lord, here it talks about composite supply of work contract as defined in clause 119 of section 2 of the Central Goods and Service Tax Act 2017, and the rate is, my lord, 9%. So CGST is 9%, SGST is 9%, so it comes to altogether 18%. Subsequently, my lord, page number 29, this notification was amended and the tax of rate for the composite supply was reduced from 9% to 6%, my lord. Page 29.
Nine, 6 and 6%.
From 9 to 6% it has been reduced. Composite supply of work contract as defined in clause 119, that is, I am reading the below, my lord, that is the clause 4, Roman 4. Composite supply of work contract as defined in clause 119 of section 2 of the Central Goods and Service Tax Act 2017. Next page, my lord. Supplied by way of construction, erection, commissioning, installation, completions, fitting, repair, maintenance, renovation or alteration of road, bridge, tunnel. So we are concerned about only the road, my lord. So the tax, the rate of tax was reduced from 9% to 6%. Therefore, my lord, the writ petitioner, my lord, who is making supply of composites, making the composite supply, my lord, they are required to pay the GST as per the applicable rate of tax. Now here, my lord, another scenario is, my lord.
So you are saying that since you make road, what's the level on the road that as were given in the...
So that is where, my lord, again I am coming. What happens when a taxable person supplies, one is taxable service supply and another is exempted supply. He is supplying composite supply.
But he is accepting the proposition that he supplies also non-exempted component of the entire supply that is giving?
I'm not accepting, but for a moment, if we take into consideration also, yes, assuming
if
yes,
one component of a service is
exempted supply
is exempted,
yes,
that means suppose like
what happens in that context?
What happens?
I'll come, my lord.
Yes.
So in cases where a person supplies taxable supply and as well as the exempted supply, my lord, what happens? That is a composite supply. Here, my lord, it's a question of composite supply. Now here in that case, my lord, I have referred to advance ruling by the Rajasthan Appellate Authority for Advance Ruling Goods and Service Tax, my lord, page number 147. Relevant page, my lord, start from 151, so that we go from the page 147. That is the Rajasthan Appellate Authority for Advance Ruling, dated 23/11/2023, my lord. Page number 147. Now here the relevant portion is starts from page number 151, my lord.
Yes, excuse me.
And before we go to that, my lord, let us first see the page number 148, my lord.
Yes.
The paragraph 3, it says the appellant MS Resonance Adventure Limited is a company registered under Companies Act 1956. They are inter alia engaged in the business of imparting coaching to students aspiring for admission into various engineering and medical colleges in India. Brief fact of the case: the appellant is registered under Goods and Service Tax so and so, under categories so and so, commercial training or coaching center service. The appellant have been providing coaching service under physical classroom mode, but due to COVID environment, they shifted their business model through remote channel partner network. My lord, may kindly come to page number 151. Paragraph 4.3. It says that page 151, paragraph 4.3.
Yes.
Yes. The appellant moved an application seeking advance ruling from the authority for advance ruling, Rajasthan, for issuance of ruling on different questions. The authority for advance ruling, Rajasthan, wide order dated so and so, pronounced the following ruling: the appellant is supplying service of coaching to students which also includes, along with coaching, supply of goods, printed material, test paper, uniform, bags, other goods to students. Such supplies are not charged separately, but a lump sum amount is charged, the major component of which is imparting coaching. In such situations, whether such supply of coaching service shall be considered a supply of goods or supply of services. Answer: in the present case, the supply is a mixed supply of goods as well as services and attract highest rate of tax at 18%, 9% CGST plus 9% SGST, or 18% in the case. So it has been, the authority for advance ruling has decided that you are supplying a mixed supply, and therefore the rate of 9% CGST and 9% SGST is applicable. And what ultimately, at page number 160, my lord, what ultimately the appellate authority,
composite supply, correct? Not
yes, this is a composite supply. Yes. Now page number 160, my lord.
In the present case, the supply is a mixed supply of goods.
No, here, my lord, that was held by the appellate authority for advance ruling. Now again, thereafter, appeal was preferred, my lord, against that advance ruling, my lord. And this is the order of the appellate authority. What ultimately the appellate authority has held, my lord, that is at page number 159 onwards, my lord. Paragraph 8.3, my lord.
Yeah.
It is also pertinent to note that the appellant has placed reliance on the Rajasthan Authority for Advance Ruling order dated so and so in respect of MS Symmetrical Infrastructure Private Limited. On perusal of the said order, we find that MS Symmetrical Infrastructure Private Limited had sought ruling on similar questions as in the instant case. We note that the AAR Rajasthan in the said order has pronounced in the ruling and answered the following: appellant supplies services of coaching to students, which also includes, along with coaching, supply of goods, printed material, test paper, uniform, bags and other goods to students. Such supplies are not charged separately, but a consolidated amount is charged, the major component of which is imparting of coaching. In such circumstances, whether such supply shall be considered a supply of goods or supply of services. Answer: supply by the appellant will be considered supply of services. 2. If the answer to the aforementioned first question is supply of service, whether such supply shall be considered as a composite supply. If yes, what shall be the principle of supply? What shall be the principal supply? Answer: yes, such supply shall be considered as composite supply, and coaching service shall be the principal supply. And order: in the light of the above discussion and finding, we hold that the authority of advance ruling Rajasthan has erred in pronouncing the impugned supply as mixed supply. On the contrary, we hold that the supply of coaching service by the appellant, along with supply of goods, printed material, test paper, uniform bags and other goods,
see, Mr. Sankwan,
is a
the thing that fine, we understand what this means, composite supply. The more predominant service or supply, at the rate is charged. Now what we are facing here in this case, if I answer correctly, is that one part is exempted and one part is not.
My lord, may kindly come to page number 170.
Now how is that addressed?
This is one notification, my lord, page number 165.
This address there.
Little bit, my lord, so that we can...
One part exempted and one part is not.
So that we can understand.
Can you see as composite supply?
Yes.
That even that you charge at the rate of the other service which is supposed to be exempted also?
Yes, my lord, we will have little bit clarification from page, my lord, may kindly see page number 165.
We have to educate ourselves also, because this is, we're not open, we're not exposed such technical.
Yes. Page number 165, this is a notification, my lord, by the Government of India, and the relevant page, my lord, page number 170. Page 170.
Yes.
The second paragraph, my lord, last portion, it says, since these supplies are ancillary to the principal supply for which the contract is signed, they shall be eligible to be assessed as the principal supply, as discussed in detail in the latter paragraph. Naturally, such supply will not be taxable if the principal supply is exempt. If principal supply here, in this example, my lord, principal supply is the coaching. Now, if suppose for some reason the supply of coaching, my lord, that service is exempted,
then even the ancillary supply of books, uniform,
they will all be exempted. They cannot, because in composite supply, only the principal supply that determines the tax liability.
Exactly. So even in our case, that means since it's taxable, so the other
it will not make any difference.
Will not make difference.
It will not make any difference, my lord.
But does it stand to reason? I mean, if it's
yes, because section 8. Clause A is very clear, my lord. It says, in cases of composite supply, it will be the only principal supply that will determine. Even if, along with the principal supply, they are supplying ancillary services, my lord. Even though those services are exempted, that will not determine the tax liability. Tax liability will be determined by the
so they
principal.
Can't determine only to sort of categorize
because
it,
here
the exempted portion be exempted and the part where they are taxable, they
consideration is, my lord, one. It is not separate, as I have already
said. 5,360 5360 lakhs is the entire consideration for the project.
One supply.
And so you are charged on that amount.
Yes.
Finish.
Yes, my lord, finish. Even if there is exemption, they cannot avail benefit of any exemptions. It will only be the principal supply that will determine, my lord.
Okay. Yes. That is, we'll have to examine.
Yes. Now, my lord, irrespective of whatever is written in the concession agreement, whatever is written, now in the concession agreement they have taken your lordship through various provision. Whatever it is written in the concession agreement, that will not make any difference.
Why?
Because as far as tax as far as
agreement entered
no, my lord, why I am saying this, only in terms of tax liability, what I am saying, my lord.
Okay.
When it comes to tax liability, my lord, it is the actual supply that will determine the tax liability. If suppose 2 persons, my lord, they have entered into agreement, they said we will supply goods or maybe services which will carry the rate of 18% or maybe 9%, my lord. But in reality, they are not supplying that service. They are supplying different services or different goods which carries higher rate of tax, my lord, maybe 28%. Now, it is not that because they have entered into that contract, entered into agreement, private agreement, that will not determine the tax liability. It will be the actual supply which will determine. Here, my lord, it is admitted by the writ petitioner, my lord. They have supplied construction service, my lord. So construction being the main supply, principal supply, my lord, it is the principal supply that will determine the tax liability of the petitioner. Irrespective of what other ancillary services they have supplied, my lord.
That's entry 9967.
Yes.
9967. One second. Anyway, yes, continue.
Now, in this case, my lord,
Then if the other hand we are allowed to take tools, then that is yes.
my lord, in this case what has happened is, my lord, it came to the knowledge of the Directorate General of Goods and Service Tax Intelligence, some of the officers, my lord, that the concessionaire is not paying the required tax for this project, my lord, whatever money they are receiving as annuity, my lord. And therefore, my lord, a letter dated 7/8/2020 was issued to the petitioner, my lord. However, in the writ petition, the letter dated 7/8/2020 they have enclosed, but this is on the same day, my lord, two letters were issued. One is to the NHA and other is to the writ petitioner. Now, what they have enclosed is the letter which was given to the NHA. Maybe by mistake, my lord. But on the same date, my lord, two letters were received.
What the letter say?
Letter says, my lord, when it came to the knowledge of the DGGI, my lord, some of the officers, they have issued this letter asking for relevant documents. And to the NHA, the same date, my lord, on the same date, another letter was issued, asking them details about how much of payment you have made for this project. So that is at page number 35 of my compilation, my lord. Page number 35.
Let's address this one. Should have argued that. The competent method is certain factor. Yes.
Now, page number 35
yes.
is the letter dated 7/8/2020. This was actually the letter which was sent to the NHA. However, my lord, the similar letter was issued to the writ petitioner seeking the relevant documents.
Yeah,
here, my lord, it says it is thus requested to kindly provide the following data information to this office for further necessary action at this end. Copy of work contract for executions of any project during the period July 2017 to July 2020, indicating terms of contract, value of contract, period of contract, etc., with the parties entities as mentioned in Annexure A enclosed. Here, the next page is, my lord, the serial number 1 is the Jorabat Shillong Expressway Limited. Now, all these details were asked from them. Now, after this, my lord, the writ petitioner has submitted the required documents and they have appeared, and they have taken the plea that they have not paid the required GST because they are exempted because of the exemption notification number 32 of 2017 that my lord has already seen because of that exemption. Now, throughout the time, my lord, several notices, several letters were issued.
23E notification.
Yes.
Yes. Then what else?
Now,
where have they said that? Where have they said that in view of the notification they have not paid that the required?
Now, the response is at page number 36.
Yes. What did he say?
Page number 36, my lord. My lord may see. Letter dated 14/8/2020, 14 August.
Yes.
They say what they say, my lord. Subject: submissions of information in respect of inquiry, investigation of GST, payments, etc. So, copies of GST certificates, all these, my lord, annexures, so and so, so and so, so and so, they have enclosed. And here, paragraph serial number 6, my lord, it says annuity is exempted as per GST Act and rules and notifications issued thereunder. Reference attaching notification number 32 2017, entry 23A.
23A,
so
right.
that they have taken the plea that there was an exemption, therefore they have not paid the GST.
Composite and mix.
Further, my lord, the NHA, my lord, in response to the letter dated 7/8/2020, they have also submitted their reply. And then they have given the details as to how much of money they have paid to the petitioner, writ petitioner, my lord, as an annuity, my lord.
Yeah.
Now, subsequently, my lord, summons were issued to the writ petition, my lord, on 6/1/2021, and for appearance on 19/1. These are all part of record, my lord. That I'm just cutting short, my lord. Now, summons were received. Ultimately, my lord, what happened? Throughout this time, my lord, they have taken the plea that because of exemptions 23A, they are not required to pay the GST amount. In the meantime, my lord, several representations were received by the Government of India, my lord, requesting for clarification regarding applicability of GST on annuities paid for construction of road, where certain portions of the consideration is received upfront, while remaining payment is made through deferred payments, that is annuity, spread over years. So after this, my lord, the Ministry of Finance, my lord, they have given a circular that is at page number 68. Now, my lord, this circular, my lord, subject it says, clarification regarding applicability of GST on activity of construction of road where consideration are received in deferred payments, annuity regarding. It says certain representation have been received requesting for a clarification regarding applicability of GST on annuities paid for construction of road where certain portion of consideration is received upfront while remaining payment is made through deferred payment, annuity spread over years. This issue has been examined by the GST Council in its 43rd meeting held on 28 May 2021. GST is exempt on service falling under heading 9967 by way of access to a road or a bridge on payment of annuity, entry 23A of notification number 12/2017. Heading 9967 covers supporting service in transport, under which 996742 covers operation service of national highways, state highways, expressway, roads, street, bridge, tunnel operation service. Entry 23 of the said notification exempts service by access to a road or a bridge on payment of toll. Together, the entries 23, 23A exempt access to a road or a bridge, whether consideration in the form of toll or annuity. Next page, my lord. Service by a construction of road falling under heading 9954. This heading inter alia covers general construction service of highways, street, road, railway, airfield, runway, bridge, tunnels. Consideration for construction of road service may be paid partially upfront and partially in deferred annuity payment. Said entry 23A does not apply to services falling under heading 9954. It specifically covers heading 9967 only. Therefore, plain reading of entry 23A makes it clear that it does not cover construction of road services falling under heading 9954. Even if deferred payment is made.
Right, we understand this. But the thing is that this letter in clarification has not referred to section 8 with definition of composite and mix.
No, my lord.
They should have made a difference. But even as annuity, which is paid in regard to tolls, that'll be exempt. But with regard to when the composite contract or composite service as the petitioner has rendered, it will not get the benefit of 23A by application of Section 8.
As far
but
as
has not been mentioned
as
here
far
in
as this notification is concerned, my lord, this is a clarification.
But it's not. It does not
What is
refer
the
to Section 8 at all.
My lord, may kindly see page number 68 again. Subject: clarification regarding applicability of GST on activity of construction of road. Here, this clarification is given whether whether GST is applicable, not applicable when it comes to construction of road. Now,
where's it 8?
Page number 68, my lord.
No, where's that section regarding composite and
composite supplies, section 8.
Section 8, yes.
Yes, clause A, my lord. Now, what this notification did is, this notification is on the basis of request made by several people, my lord. This is not pertaining to this case. Now,
so you mean to say now this has become settled position?
Yes, my lord. It is what the clarification says, my lord, and what the clarification was sought. Clarification was sought whether GST is applicable on the activity of the construction of road, my lord. That is the very important as far as our case is concerned.
We understand,
because our case
submission is that petitioner, the service given is construction of road.
Construction of road.
Blanket principle does not apply. Whatever service might come under construction of head road ancillary service that they give,
being the principal supply.
Being the principal service they are rendering, they'll be liable to GST.
Right.
That's all.
That is all.
It might be called annuity, might be called anything, but since the principal service is that.
Now, why construction of road is the principal service, principal supply is because how we can determine whether it is the principal supply or not. Because the other ancillary supplies which the petitioner is saying they have supplied, like maintaining the road and then giving access to the road, these supplies will not come into picture if the road is not being constructed. So the first road comes, then only these ancillary things come. Therefore it is the principal supply. So principal supply in cases of composite supply, my lord, it has to be naturally bundled, because
you understand, composite supply has to be it's related goods. Like I was saying, like the phone and the charger.
Right.
But in the mixed supply can be
independently. It can be
a bundle of goods. Can be a book, can be a pen, or can be.
It can be supplied independently.
Right.
Yes. Now, my lord.
Yes.
And petitioner has contended that because of this circular, GST has been made applicable for the construction of road, what they have contended, my lord. And they said this is against the exemption notification. That is absolutely not true, because the inquiry and investigation in this case has started since 2020. And this notification, my lord, this is 2021, my lord, this circular. So inquiry investigation started much prior to this circular, my lord. It is never a case that because of this circular, my lord, the GST has been made applicable in the construction of road. That submission is not correct, my lord. Now, another contention, my lord, which the petitioner has raised is, if any clarification has to be given, that has to be given within a period of 1 year, my lord. Let us see, my lord, the section 11 clause 2 of the GST Act, my lord. Section 11 clause 3, my lord, it says, the government may, if it considered necessary or expedient so to do, for the purpose of clarifying the scope or applicability of any notification issued under subsection 1 or order issued under subsection 2, insert an explanation in such notifications or order as the case may be by notification at any time within 1 year of issue of the notification under subsection 1 or under subsection 2. This period of limitation of 1 year is applicable only in cases where the government wants to insert an explanation in the exemption notification. there was no explanation that was inserted in the notification. Therefore, my lord, these limitations, my lord, which the writ petitioner has said that will be applicable in this case, my lord, that is not correct, my lord. Now, on scrutiny, my lord, of all these documents, my lord, which the writ petitioner has submitted,
so you mean to say that this section, coming back to section 11.3, clarifying the scope of duty of issue of one order so insert explanation. So you mean to say that if it's a pure clarification, standing independently, it will not be hit by section 11.
No, my lord, it is only for the
then whether it will have any force of law, then it's clarification.
My lord, here
if it doesn't come as an explanation to the
this, because this clarification is only for the purpose of understanding, only for the purpose of
cannot have the force of law.
It is not. It is this. In fact, this circular, my lord, it has not done anything. Because of this circular, no tax was imposed. This is merely an clarification which was given to the people because people sought for the clarification. It is never a case that because of this circular.
I mean, it's as good as some author in his manual explaining.
My lord, government. If suppose somebody asks for clarification, the government can give such clarification to the public.
What is the status of this clarification?
Clarification
amount and explanation.
As long as it is not imposing new tax. Now, if suppose tax has been imposed or maybe exemption has been given
by the clarification.
It cannot be.
It cannot be.
It cannot be by way of clarification. But
so you mean to say that even if it takes away the
it is not taking away because
the scope of 23A also amount of explanation.
It is not, my lord, because tax liability in terms of
the questioning, just floating the air.
Because tax liability is in terms of the notification issued by the government. I have already taken your lordship to the notifications which says tax liability for component supply is 9, which was subsequently reduced to 6%, my lord. Any tax that has to be imposed, that has to be imposed by a specific notification. It is not by a circular, my lord. This circular, in fact, has done nothing. Only it has clarified to the people who have sought for such clarification. It is never a case that because of this circular, tax was imposed, my lord. Now, my lord.
Yes.
After the documents were supplied by the petitioner to the to the authorities, my lord, they have discovered that around 800, my lord, I am just giving a figure, my lord, that is not correct, around 811 crore something, my lord, plus, that was declared to be the exempted supply. And they have not paid GST in view of, in the guise of entry 23A, that they said it is exempted. Now, another contention which the petitioner has raised, that the construction work, my lord, it completed prior to GST came into picture, my lord. And therefore, they are not required to pay GST. Here, my lord may kindly come to section 142.
Yes.
142, clause 10. It says, my lord, save as otherwise provided in this chapter, the goods or services or both supplied on or after the appointed day in pursuance of contract entered into prior to the appointed day shall be liable to tax under the provision of this act. Even if the agreement has been entered into prior to the coming of GST, my lord,
yes,
the tax will be imposed in terms of.
Yes.
And here, my lord, it becomes very important to find out what is the taxable event that determines the tax liability of the concessionaire, my lord. Now, when you talk about, my lord, the taxable events, my lord may kindly see section 13. Section 13.
Yes, time and supply.
Yes. Time of supply, my lord. Section 13 says, my lord, the liability to pay tax on services shall arise at the time of supply as determined in accordance with the provision of this section. Clause 2 says the time of supply of service shall be the earliest of the following dates, namely the date of issue of invoice by the supplier, or the date of receipt of payment, whichever is earlier. Now here let me see, the invoice has been issued. The copy of the invoice is already there in the writ petition, my lord, which they have enclosed. These invoices are issued as and when they are receiving the amount, the annuity amount. So this,
they all post term 17.
yes. So and then they are receiving the payment also in today's date, and therefore in view of section 13 and also section 142(10), they cannot take the plea that because the construction was completed prior to coming of GST, my lord, and they are not entitled to, not required to pay this GST. That is not true, my lord.
Yes.
Now,
yes.
After, my lord,
How long will you take?
My lord,
How much longer you'll
my
take?
lord, I will take some time, my lord, because there are so many things, my lord, which are to be explained.
Because we intend to break the bench at 12:30. The single bench matters.
My lord, we can continue on the next bench.
Yes, Dr. Mozika, how long will you take? Will it be possible to encapsulate it into one day?
Next day, my lord, will try to conclude, my lord.
For what about Ms. Basante? You no replies.
Let him finish first, Your Lordship. We'll reply.
Then whether it, okay. Let
Your Lordship, Mr. should do the rebuttal on 19th of August. If the other side
to reply.
should go there.
Okay, very good. 19th August is what? The Tuesday. Okay, yes, hearing inconclusive to continue on Thursday.
19th.
19th.
Your Lordship, Mr. should do the rebuttal on 19th if they can finish any day prior to that.
Thursday, no? Thursday, can I? 7.
Before 19 will be 14. 14.
This Matagari will be Tuesday, Thursday,
Thursday, of course. Thursday.
Yes, well, it's still fresh. We're getting on Thursday.
My lord. Oblige.
Supplementary list, pronouncement of judgment, item number 1.
As this court has also come to a finding that the impugn order is unsustainable, in view of the same being visited by arbitrators and there being a breach of principle of justice, the same is set aside and quashed. However, as no interim orders had been passed, an impugn order having been passed as far back as on 28/4/2025, it is ordered that status quo from today shall be maintained by the parties till the matter is disposed of or further orders passed by respondents number 2 and 3. It is further expected the matter shall be dealt with most expeditiously by the respondents 2 and 3, and the same be disposed of in a period of 2 weeks from the date the parties are put to notice. It's a longer judgment. You can have a look at it. Yes. Obliged. Yeah.
Any mention?
Please, Your Lordship. Your Lordship, I beg to mention item 15, 16, 19 and 20, Your Lordship. Connected matters. May it come after a week, Your Lordship.
1 second, let me open the list at least. 15,
16, 19 and 20.
These matters are very short matters.
After a week, Your Lordship.
These are short matters, not very, already Lordship has already decided the matter.
then why they're still in the list then? You've already decided the matter.
The earlier order of the Lordship has not been placed along with the repetition, Your Lordship. And the earlier order, Your Lordship, the empirical exposition was decided by. But they may have it after 1 week. But,
a week, Lordship.
Oh, he is, sir. Yes, after 1 week, on the prayer of the petitioner.
Highly obliged.
Highly obliged, Your Lordship.
Yes.
Please, Your Lordship. Your Lordship, I'd like to mention item number 22, Your Lordship. We have the respondent number 5. Please, Your Lordship, can have this matter.
It's regarding the denial of... No, Lordship, it's regarding the appointment, Lordship.
Teacher.
Appointment, Lordship, yes, Lordship. Denial of appointment in lieu of land, Lordship.
So from there, it's on teacher or VC now. Only cases that are coming. Yes, no objection?
No objection, Lordship.
Okay, 2 weeks, yes. Yes.
Much obliged, Lordship.
Please, Your Lordship. Lordship, I beg to mention item number 14, my lord, on behalf of Mr. N. Sincon. Kindly have the matter after 2 weeks, my lord.
14?
Lordship.
This matters, who's on the other side? Mr. Gautam.
For respondent number 1, Lordship.
Yeah, objection?
No objection, Lordship.
It's only to close this matter. If you don't have other instructions, we will close it. It'll be to your detriment. That's all.
Will come after 2 weeks, my lord.
Okay, yes.
Deeply obliged.
Yes.
Supplementary list, item number 2.
Yes.
My lord, we have filed an application for appointment of an arbitrator.
Section 11.
11, my lord. My lord, it's a covered matter. My lord, similar matter had come up.
Let him take instructions.
I'll file an application.
Yes, heard.
My lord, one impediment is there that they have now issued us a notice for termination of the contract. It has not taken
the remedy
effect.
for that lies somewhere else, my lord. In section 11 application.
I'll file a section 9, my lord.
Yes, heard Mr. N. Kera. You should notice Dr. N. Muzika and GSTI with so-and-so is present on behalf of the respondent's number. Only one sole respondent, no further required. Just for tweak for instructions. Yes.
My lord, if I may, my lord, they may come with the name of their arbitrator here.
They know what to do.
So no, because it's a covered matter, my lord. Arbitration case number 3.
Same panel will be there.
Same panel.
Yes, Dr. Muzika also submits that
I'll file an affidavit. I'll disclose all that.
the names of the applicants will be indicated in the affidavit to be filed.
Item number 3.
Obligement.
Same Mathur only? No.
May it please, Lordship.
Yes.
Lordship, this is a contempt petition, Lordship, for
Which order?
for non-compliance of the order dated 6/11/2024. 2024. Page 11, Lordship. Page 15 is on the earlier occasion we have filed, but due to some defect we have withdrawn this petition, Lordship.
Yes, outstanding liabilities 10 lakhs. Who appeared last time?
Last time,
I Lingwa. Yes, they have not paid.
no, Lordship.
4 months. 4 months over.
Yes, Lordship. Now 8 months, Lordship. 6/11/2024, Lordship.
Yes, heard MS GT Sama, correct? Yes, issue notice. It's returnable in.
My lord, she's on legs, my lord, before court number 4.
No, it's still a fresh matter. Issue notice returnable in 2 weeks. Steps were taken within 3 days. Just thereafter on so yes.
Obliged.
Item number 4.
Yes, Mr. Pathak.
There is a non-compliance of 18 March 35. But of this technically, we directly went to the
Sorry, Mr. Pathak, I don't think. Mr. Pathak, can you hear the court? What happened to? Mr. Pathak, can you hear the court now?
Am I audible? Hello?
Yes, now you're audible, yes.
Yes, my lord.
Yes.
I hear the page 103, my lord, is the effective part of the order. So much time was, my lord, granted to comply as far as rank and pay parity to clerks is concerned. That had expired on 18th of July, and hence this petition.
Yes, heard Mr. B. Pathak, learned counsel petition issue notice returnable in 2 weeks. Steps were taken within 3 days. List on so and so, yes. Yes.
Item number 5.
May it please, Lordship. Lordship, this matter pertains to the forceful and illegal demolition of a house. Lordship granted under the PMAY Graham scheme. I belong
demolition of a house?
Yes, Lordship. There's an illegal demolition by the respondents of
Which
my house.
respondent?
Respondent number 5.
Private respondent?
Yes, the private respondent, number 6. And Your Lordship, I'm in possession of a land for the last 30 years. And when I started construction of the house...
5 is a sardar of, what's this?
Yes, number 6 is the headman, Matabor, of Maukhliao village. Your Lordship. So, Your Lordship...
They came and demolished your house?
Yes, Your Lordship, illegally. I have filed an FIR to the extent, Your Lordship, but no action was taken. I have filed a complaint as well, reported to the Superintendent of Police, East Castles, to the extent that no action has been taken.
That, what, PM?
PMAY scheme, Your Lordship. It's a Prime Minister...
Where have you said that?
Lordship, it's an... The work is at paragraph number 9, Your Lordship.
No, next year. What order?
The work order is at page 23, Your Lordship. Annexion number 2.
This is your name?
Yes, Your Lordship. I'm the petition number 2. Your Lordship, the land is in possession of the petition number 1. The petitioner number 2 is the youngest daughter.
No, why did they demolish your house?
For no reason, Your Lordship. the main.
It's not possible. Someone just come one fine day to demolish your house.
Yes, Your Lordship. I'll come to the facts of the entire case, Your Lordship. Lordship, I was granted of the scheme when I started to construct the house. At first instance, even the respondent number 6 did not make any interference. However, when I started to finish the construction almost, Your Lordship, prior to that, as per the scheme, I'm also entitled to put in some financial or some money, Lordship, to the development of the house because it's a shared, is on a shared basis as per granted by the scheme. Now, Lordship, when I constructed the house, there has been no complaint or allegation whatsoever by the respondent number 6, and they issued me a letter. Your Lordship, at first instance, they issued me a letter which is Annexure 6, Your Lordship. The translated copy is at page 33. That there has been an allegation against me. A complaint that this land belongs to the respondent number 8, respondent number 7 here, Your Lordship. So, respondent number 7 is a women's social welfare organization, which is a women's organization in the Maukle village.
Or you mean to say that you went and constructed a house on that land given to them?
Yes, Lordship. But at first instance, Lordship, I have been in possession of this particular land since the year 1993. Till present.
When was this work started?
I beg your pardon?
For construction.
It started in the year 2024, Your Lordship.
24?
Yes, Your Lordship. And there has been no...
At that time they gave the objection?
Yes, Your Lordship. And prior...
You continued making it?
No, prior to that, Your Lordship, I have a house already constructed in my land. And there has been no objection. Now, Your Lordship, the entire facts of this land, it was entire land...
See what this complaint says. You have forcibly destroyed the office secretary on 19-2. You went and demolished some structure?
No, Your Lordship. That's not the fact of the case. Now, Your Lordship, many Dorbar was called by the respondent number 6, to the extent that it has reached to the respondent number 6 for clarification of the entire issue. Now, the respondent number 6, Your Lordship, remanded the matter to the respondent number 6 for clarification. So they even stopped me from fencing with the matter and we complied. But however, Your Lordship, since a house is already standing therein, then we have stopped. And later in the month of November 2024, Your Lordship, without assigning or giving us any notice to show cause, they come with a GCB and demolish the building that I've already constructed in the PMAY scheme. Now, Your Lordship, apart from the recent photograph is at page 17, Your Lordship.
17?
Is a recent photograph of the demolition, Your Lordship. 17, Annexure 17, which is at page 59.
I've seen them looking at that right now.
And now what follows, Your Honor, there are subsequent cause of action.
But he didn't report it to the police.
We have reported nothing, no action was taken, Your Lordship. The FIR is at page 64, Your Lordship, which is Annexure 18, page 65. And immediately on the same day, Your Lordship, I have reported to the respondent number 5, which is the BDO, or respondent number 4, which is at page 66, Your Honor, Annexure 19.
You didn't go to the district authorities?
I went, Your Honor. And what follows, Your Honor, the subsequent event is that at page 68, Your Honor, which is Annexure 20, the translated copy is 69, whereby I was asked by the BDO to refund the entire money which was granted under PMAY scheme. Now, subsequently, I reply that I cannot give the entire money as whatever the construction...
Oh, that's why, because you got the order for refund, that's why you've come to court. And all these things happened in 2024.
Yes, Your Honor.
Now we're sitting in August 25.
No, Your Honor, there are subsequent events, Your Honor, which I have highlighted in paragraph number 28, Your Honor. Where apart from this, Your Honor, there has been other subsequent events whereby they excommunicate me from the village, Your Honor. And subject to which they interfere with the job card which are meant to me under the scheme.
Multiple cause of action they are having.
Yes, Your Honor. So for the reason I have approached before Your Lordship at this
Yes, Your Lordship.
Yes, Lordship.
So for the first part of the writ petition it is a civil dispute. There is a claim and counterclaim regarding a plot of land, Your Lordship. But so far the allegation that no action had been taken by the police, there is a statement at paragraph 26. Your Lordship, kindly come to page 13. Paragraph 26. a non-FIR case has been registered, the Lordship. And Lordship, a notice has been issued. Lordship, kindly find, Lordship will find it at page 76.
1 second.
There is a clear statement at paragraph 26, Your Lordship.
That's the page 76.
Then Lordship, kindly have the notice at page 76. This is the notice issued by the Executive Magistrate Sora Civil Subdivision.
Dated when?
Dated, Your Lordship, 15/4.
What happened after this?
Nothing, Your Honor.
After 13 May 20, nothing happened?
Nothing happened. But, Your Honor, there are subsequent events whereby the respondent number 6, he made announcement publicly and excommunicated me from the village.
Where's the order of excommunication?
You know, we do not have any copy, but they have made by way of announcement by the Matabor, the respondent number 6. And presently, Your Honor, even the petitioner number 3, Your Honor, he's been directed to stop. He's working as a master role in PHE and he's maintaining all the pipelines.
Who's number 3?
He's a husband of the petitioner number 2, Your Honor.
Now you can't club this cause action in one basket. Like he's doing.
No, but the entire action is by the respondent number 6.
Your house been destroyed. You can't have all these things in what I can understand the consequences. Okay, house destroyed.
But the chain of events and the
communication, but not that fellow has to file his own petition.
But Your Honor, the chain of events and the circumstances, it flows from the same action of the respondent number 6.
Where is the factum of this prohibitory announcements? Where have
there
you,
is nothing as such, Your Lordship.
You know, we do not have the copy, but public announcement was made. But Your Honor, I have the chain of event. I have narrated in paragraph the statement of facts in paragraph 28. Your Honor, may I read?
Yes, Mr. Shulai. You take instructions.
Lordship, so far this, I don't know whether it's correct or not, Your Lordship.
Take instructions. Yes.
Lordship, I'll have instruction, Your Lordship.
We should notice to the Sardar, headman, whatever, Sardar Raj and...
You know, the actions of the state respondent in issuing for refund also is a matter of very much directly connected with the matter.
As on the counsel for the petitioner. So we should notice Ms. Eldishwa AAG is present with Mr. E.R. Khan. For the respondents number 1 to 4.
1 to 4, Your Lordship.
Such no for the notice of these respondents. Petitioner to take steps to issue notice on the remaining respondents within 3 days. Stop. Next, the grievance as projected by the petitioner is that firstly, a house which was sanctioned under the PMAY scheme, PMAY-G of 2324 has been demolished by the respondents number
6,
who stated to be the
Matabor.
He is the Matabor, headman of Maukuliao and Kemrang village, Soras Imship. Stop. It has also been submitted by the counsel for the petitioner that pursuant to the demolition of the said house, the petitioner has also been ostracized by the village, ostracized or excommunicated by the village, and also has been deprived of the benefits of the MNGRES scheme. Stop. Further, he submits the respondent number 3 also has sought for recovery of the amount advanced to the little petitioner for construction of the house.
Only 2 installments has been cleared, Your Lordship.
Whatever the money always advanced to the little petitioner for construction of the house, that's been demolished. Stop. Next paragraph. I therefore prays for appropriate directions at this stage itself for the safety and security of the petitioners. Oh no, not necessarily. He prays appropriate and what is the stage for to stop recovery of the payments which have been received. Stop. Mr. Andy Shulai submits that from the materials AAG, it appears that FR has since been lodged and a non-FIR case has been registered. He prays to be allowed to obtain further instructions in the matter. Stop. On hearing the counsel for the parties, it appears that the petitioner from the it appears that this is not denied. I think these pictures are correct.
Yes, Your Lordship.
And we won't pass it.
Your Lordship, as of at present as well, there's a cultivated land has been forcefully.
Lordship, that so-called incident happened sometime in the month of May, Your Lordship. In month of May.
2024. Tom, yeah. Adam. So stop next paragraph on here. The counsel parties. This is matter after 10 days. Petitioner to take steps by justice service upon the party respondents. Service also provided that until the next date, the respondent number 3 shall not make any recovery of the advance amount to the petitioner. Let them come. Let's see what they have to say. And we can relegate you to civil court after that.
I'll oblige.
Daily list, item number 1.
Yes. Yes.
The procession was held, Your Lordship. There was no complaints from any
Yes,
side.
only one thing is that where's the other, the division bench has sent the order. Where's the division bench order? Division bench order. Division bench order to the past. There's no one appearing for that petition person today.
It doesn't appear. It doesn't appear so.
What are parties in division bench matter?
My lord, if lordship looks at the order, the cause title, multiple parties, my lord, 17 respondents.
You're appearing for whom, MS Yangi?
In that matter, I'm not appearing for anybody.
Who appeared in division bench for the state?
I think Mr. Shulai appeared for the state.
I appear before the division bench, Lordship, yes. For the state,
Who appeared for the union?
For the union, Dr. Musika is there.
Dr. Musika.
Dr. Musika was there.
For the union.
For the Union of India.
Dr. Musika.
Dr. Musika, Your Lordship. And for the district council, Your Lordship, Mr. Thimas Dingdo. Tiki Dingdo he was appearing. Your
And office of the CM of Himawatandra?
Mr. Shangraiso and for the headman of that particular village, Your Lordship, I think. I forgot that.
Yeah, 3. Yeah, 3.
Yes.
Armaja, Your Lordship. Lordship, kindly come to page 2 of that judgment of the division bench. The name of the appearing counsel is there, Your Lordship.
Yes.
Armaja is for respondent number 16. Mr. Shangraisu, Your Lordship, for R17, Your Lordship.
Because there's an order for mediation.
If Lordship kindly come to internal page 5. 1, 2, 3. Lordship,
So
kindly.
we need that vision person, because see, the thing is that we will refer to court mediation. I don't know whether it's successful or not, as per direction of division bench as well. And then we will see after that. With regard to the other matter, we'll post further orders. The yatra has been held.
Held.
There's no untoward incident. It's been, anyways,
Well,
Yes, what do you say?
Successfully.
Happy to report,
So then
my
we
lord.
have to put in the SOP.
But the committee has to be formed.
No, committee will form, will pass for the orders. First, we'll just pass ordinances once. As the when the last order after division bench one?
Yeah.
26/6.
This is the division bench. This is the order. You can just put this together. Last order is just.
Not conflict alone. Add to you, eh? Just take down like this. In the last few orders passed by this court prior to the order dated 26/6/2025 passed in PIL number 3 or 2025 by the division bench of this court. This court was engaged with the matter concerning the holding of pilgrimage or yatra on a consensus between all parties, and as such, after the matter had been, how do we say, remanded? We can't say remanded, sent to this court.
Sent.
After PIL had been sent to this court for necessary orders, the same has not been, no orders have been passed thereon. Stop. I'm pleading.
The gentleman had appeared once, Your Lordship.
Yes, I'm pleading.
He's impleted as number 9, my lord. Respondent 9.
Correct. Yes, of course. Yes.
Yes.
This court also by the name of the petitioner in PL number 3 has also been added as respondent number 9 in the instant petition, but however is absent today. Stop. It is noted that the order of the division bench had directed that an effort should be made to resolve the matter amicably through mediation, stroke or settlement. Stop. And as such necessary orders, necessary to be passed in this regard. Stop. However, due to the absence of the petitioner in person, we post the matters posted to
After 2 weeks, Your Lordship.
for 2 weeks. Registry will have to issue notice to him.
Noticed.
Yes, 2 weeks for further orders. With regard to this other matter, any other orders necessary right now?
My lord, the only pending aspect I would humbly submit is the formation of the committee.
No, that also will record, yes. Will record, yes. Anything to say?
Nothing to say, Your Lordship. Except formation of the committee, Your Lordship. We have already given the list of the members who are supposed to be
No,
proposed.
we wanted two members from civil society to be member of this
Yes,
committee.
that we tried, Your Lordship. In fact, we have submitted
With regard to
one.
addition of members to the committee.
Your Lordship may
take the
kindly
matter further.
appoint,
Yes, we tweak further.
nominate
This,
yourself, Your
necessary
Lordship,
orders
because
we pass on the next date. We will examine, yes. this
because
for 2
the
weeks.
list submitted by both the things are
No,
not
this have to tweak. We'll mark
acceptable,
it.
Your Lordship.
Obliged.
Obliged, Your Lordship.
Item number 2.
Notice you continue.
Still pending, Your Lordship.
6 weeks, yes.
2 and 3 are connected, Your Lordship. Obliged, Your Lordship.
Yes, for 6 weeks, the matter is still pending consideration for the Supreme Court.
Obliged, Your Lordship.
Item number 4. Item number 4.
May please, Lordship. Lordship, we have filed our counter affidavit, Lordship, in this matter.
filed?
Lodge. In fact, my lord, a counter affidavit had been filed long back, and my friend had taken lordship's permission to file a more detailed affidavit. Going through that, my lord, we see that it is the same original counter affidavit, but in more fancier language and more elaborate submissions.
So give him credit for that.
My lord, absolutely, absolutely, my lord. My only humble request was that we had originally filed a rejoinder to the original.
That will suffice.
That will suffice, my lord.
Mr. H.F. submits that the detailed affidavit has been filed. To which Mr. Isdinal says no further rejoinder will be necessary. Only release the matter for hearing.
For hearing.
Yes, after 2 weeks.
Obliged.
Item number 5.
Please, Lordship. Lordship, in this matter, the service is completed and the matter can be fixed for hearing. Yes, Your Lordship.
Today is fixed for appearance of all the parties, madam. The transfer petition, madam.
They not appeared. Well, how many parties are there?
Altogether, my lord, the respondent number 2.
Victim?
My lord.
Victim?
Complainant.
Who's number 2? Complainant?
My lord.
You said that you served when? Where's the affidavit filed?
On the last occasion, my lord, that was filed.
Yes, though they submitted that notice complete by house number 2, no appearances. Today also there's no appearance. So what should we do? Proceed with the matter?
In the meanwhile, my lord, if respondent number 2 desires to...
For hearing.
My lord. Bunch of similar matters are coming on 11th August.
Suppose the matter on 11th, so and so with other connected matters. Yes.
Deeply.
Item number 6.
May I please, Your Lordship, since there is
You
no...
file objections?
You won't be filing.
You filed?
We will not file, Your Lordship.
Last occasion, Lordship.
You took time to file objection?
No, Lordship.
We will not file, Your Lordship.
You're not filing, then we'll delay we'll condone the delay.
Yes, Lordship.
As Mr. Pasantia for Assam 456 and Ms. Idahar 1, 2 and 2 submit that no objections be filed. The matter is taken up for consideration today itself. Where's the condition application?
354 days.
We could put order in it. This case review number 1. No? Watch it one. Come this case number 1. You don't file objections where the review should not be allowed. Will you file objection to the main review application?
I'll seek instructions with regards to the main review.
Shall be condemned.
So you have no problem with condemnation?
No, Your Lordship.
It's 354 days delay.
As per the last order, then my conducting counsel submitted that we won't be filing.
No?
Yes, Lordship.
Order says, see, last order says Mr. Parson P.O. will count for 4, 5 and 6 submit he has not received a copy of the application for condemnation. Order 27/6/2025.
Lordship, in Miss case. In
That
Miss
is
case,
review
Lordship.
petition main one.
Miss case 1 is there, Lordship.
Okay.
Yes, Lordship.
18/7. Will you file objection to the main review application?
Seek instructions, Your Lordship.
Take down a thumb on that. Yes, so accordingly, for the reasons stated in the condemnation application, the delay of 354 days in referring the instant review petition against order of dismissal dated 23/04/2024 pass the WPC number 233/2023 is condoned. Just registry to diarize, to register and diarize the review applications. Stop. The review petition is just after 2 weeks. Yes.
Your best lordship.
Item number 7.
After orders. Huh? Orders upon? What are the orders?
May it please your lordship. Your lordship, the pleadings are completed, your lordship. Matter may be fixed for hearing.
You filed it?
They have filed a rejoinder,
They
lordship.
rejoined the affidavit.
Your lordship, I'm hearing for the private respondent number 5 and 6. We received their rejoinder to be exiled.
You're not filing and no other.
No, lordship, we've already filed that.
We already filed, yes.
Your lordship.
I'll submit the pleadings to complete. Only is a matter for hearing after 2 weeks. Yes.
Right.
8. Item number 8.
Please, your lordship, this is that contempt matter where the petitioner had donated his land with the assurance that he'd be given a job in the PHE department. The recent instruction that I have is contained, the entire sequence of events are contained in this letter, my lord. So I must apologize, the matter has not been dealt with swiftly by the department, my lords.
Yes.
If you lordship, can you see the sequence of events? It would show, as far as I am concerned, my lords, there's no
Have you
willful
filed affidavit
default.
here? No.
We have already filed an affidavit, my lords.
Yes, Mr. S. Sen today has placed for the court detailed instructions dated 21st July 2025 that show that the government in the PHE department is awaiting government approval.
My lords, and this matter is presently pending with the finance department.
For creation of posts of Khalasi in the same finance department. In that view, the matter, this is matter after 2 weeks. You give a copy of the communication. Copy will be given to made over to the council petition also.
Thank you, Mr. Lordship.
9.
May it please, Lordship. Lordship, this matter concerns freezing of writ petitioner's account, Lordship. Affidavit on counter affidavit on behalf of respondent number 3 is ready, Lordship. We have sent for signature, Lordship.
Your Lordship, on behalf of respondent number 1, within 2 weeks I will be filing. I receive pair-wise comments and draft is ready.
What about number 2?
They have not yet entered appearance, your lordship. They have not entered appearance.
State of Gujarat. State of Gujarat, Lordship.
Yes, Mr. S. Pandey for number 1 or for number 3, and S. Varasati. In the course of the day, you're filing.
No, your Lordship.
Lordship, I'll try to file it in the course of the day, Lordship.
No,
But if further 1 week's time to file affidavit. 1 week.
Much of that,
Thereafter,
10.
Your Lordship, as per the last order, final opportunity was given to respondent 3 and 4.
Lordship, yes. I'm appearing on behalf of Ms. Haras Imyong, Your Lordship. She's in bereavement, Your Lordship.
What is the matter about?
This is non-issuance of pata at Dingpaso village, man.
For some time, Your Lordship.
Are you appearing for?
Respondent number 2, Lordship. So we won't be filing after.
Okay, as the counsel for respondent 3 and 4, also claim instructions still been bereavement just after 2 weeks. Yes.
Highly obliged, man.
11.
Please, Your Lordship, respondent number 4 and 5, bank, HDFC Bank. We would require some more time for the affidavit, Your Lordship, because there are too many transactions.
Too many?
Too many transactions, Your Lordship.
It's freezing our account also.
That's the other one
This is
aspect.
a fraud committed by a bank employee, Your Lordship.
The manager of the bank employee.
Mr. Hazarika, are you appearing for
I'm filing
6?
today.
I'm filing today. Mr. Pandey, 7?
I'm appearing for private respondent number 7, Lordship.
Yes.
I require 2 weeks time, Lordship.
The one that reported everybody?
Lordship. She is the
Branch manager.
branch manager, Lordship.
Mr.
4 and 5 is the bank.
1, 2, 3. 4 and 5 the bank. How long you, what time? 1 week?
At least 3 weeks, Lordship.
Yes, as Marpan 4 to 5 submits that as the records are convoluted.
Yeah.
We wouldn't say convoluted, as the records are what records you saying?
There are too many transactions, Lordship.
And the records contain innumerable transactions for the time required for an affidavit. He prays funds allowed 3 weeks time to complete the same. Mr. P. Hazarika for from the 6 submits the affidavit on behalf today being filed in the course of the day. Ms. S. Pandey, similar prayer.
Similar prayers.
For 2 weeks, 3 weeks time. This other 3 weeks is.
Much obliged.
Item number 12. 12.
May it please your Lordship. Lordship, item 12 and 13, your Lordship, have become infructuous, your Lordship.
No, Lordship. Lordship, they have conducted the verification, Lordship.
I expected an answer only to say no.
Lordship,
why not infructuous?
Lordship, I may be allowed to file a response to this report, Lordship.
Lordship, kindly, if
Lordship, what has happened,
Lordship? Petition. Lordship, kindly have the writ petition at page 19, your Lordship.
Yes.
Can you please stand up, sir? Petitioner. Lordship, my grievance is
page 19, your Lordship. Kindly have at page 19, your Lordship, the writ petition, that is the relief.
Review the job card list.
Lordship, yes. Lordship, Lordship, kindly have the report which we have filed, your Lordship.
I'll come. I'll reply.
The affidavit.
Lordship, we filed the report, your Lordship, on 1st August, your Lordship. Kindly have
my affidavit.
Lordship, yes. Kindly have that, Lordship.
29.
Lordship, yes.
This one? Page 29.
If Lordship kindly have paragraph 4 at page 2. Paragraph 4 and paragraph 4, your Lordship. And Lordship kindly see the.
Yes, Mr. Rongpur will close it.
Lordship, kindly come to page.
Don't challenge the report here in the same petition. Your praise different and what has been.
Lordship, what they have done in Lordship. Lordship, I have filed my
cause of action.
Lordship, kindly hear me for some time. Lordship, kindly come to page 11, Lordship, of my writ petition. Page 11 of my writ petition.
Go by your prayer.
Lordship, that's why this is important, Lordship. Page 11.
Yes.
Now I've sought verification of these job card holders, Lordship. Page 11, 12, 13, 14, 15, 16, Lordship.
All found to be false.
No,
That has
Lordship.
been done, your Lordship.
And the verification was not done in my presence, Lordship.
Who are you?
I'm the petitioner, Lordship. One of the job card holders.
In your presence?
Lordship, because I had sought verification of these people, Lordship. Now the report says otherwise, Lordship, and the report was not.
They all valid.
And what they've done, Lordship, they have conducted verification of the entire village, Lordship. And the burden is on me, Lordship, because I've only approached for these people, Lordship.
400.
Lordship, allow me to file a response to this report, Lordship. Just a week's time, Lordship.
Have been were found to be genuine, your Lordship, and
Friday, yes. Yes.
Lordship, kindly have page 2, paragraph 4.
We're not opening the thing is that these matters. The thing is, see, if you ask for verification, notwithstanding against whom the people.
We have done it. We have carried out that exercise.
I agree, Lordship.
Now, if the bigger exercise has been conducted, whereby they've detected some, who are not valid job cards,
and we have removed that also, your Lordship.
From the list, they've generated.
So far as my grievance that is not addressed.
Report.
My grievance is not addressed, your Lordship, because these persons.
You ask for verification, done verification.
Lordship, kindly allow me.
More than they've gone over.
Lordship, allow me 1 week time. I'll file a response.
To the people that you have some grievance against, they've done the whole village, and some people have been affected now, I guess.
Lordship, allow me 1 week time. 1 week time to file a response to this report, Lordship, because it's quite a bulky report, Lordship.
In my humble and respectful submission, your Lordship.
Lordship can take a call on the next day.
Though Mr. Andy Shulai, AG with so and so, has submitted that petition kind of fructuous, in as much as the prayer made therein for verification of job card holders has since been completed. Mr. Emil Nongpur, Counsel for the petitioner, has voiced objections and prayed that he may be allowed to file a small rejoinder to the report that has been filed by the state respondents. Yes?
Lordship, similar item is also 25.
You also have objection to the inquiry report.
Lordship, in item number 13, I have received the inquiry. The issue is sealed. In item number 12 and 13, the
Yes.
issue is sealed. But I have received the verification report this morning only.
Lordship, so far in
item list after 1 week for rejoinders, if any, yes.
Lordship, in item 13 there is a stay operating, your lordship, and lordship, this is
after 1 week
welfare scheme, your lordship. In the meanwhile, your lordship, if lordship allow us
1 week exactly. List the matter
After 1 week, lordship.
after 1
Lordship
week.
can take a call, lordship.
That is on 12.
12, lordship.
Because I'm concerned, your lordship, because they
I understand your deep concern, of course.
Lordship, there's one more matter. There's one more matter connected to the same VC. Item 25, lordship. It's in
13
today's list.
and 25, lordship, will come together.
And 25 as well. Oblige.
Highly apply, your lordship.
Hearing will take up 10 days.
Apply, your lordship.
Please, your lordship. Lordship, item number 23, my lord.
Mention it when it's
Lordship.
put some together.
Lordship.
Documentary list. Hearing item 6.
What did you hearing say? Wanted to mention earlier on hearing?
Any mention?
With Mr. Mumin. He's ready to, now he's ready. Second half to do. Yes. Thirteen is there? 13?
Yes.
13 is the list.
Any mention?
That's okay. Yes. Yes.
May it please your lordship. On the last occasion, my respect.
Affidavit you filed.
No, I filed the affidavit yesterday, but on the last occasion, instruction was placed from the Ministry of Home Affairs saying that.
That is what. No, before we start with you,
yes.
That is all. We want to have some clarification from Dr. Muzika. Yes.
What they've stated is that as of now we are not in a position to give a fixed time. It may take 3 months, it may take 6 months.
To allow him to resign?
To get an alternative.
No, I mean, how long will it take for you to get alternative to allow him to resign?
Well, what we have done is we have written to the MHA, my lord, to provide us a deputation, some one orthopedic.
How long will it take?
We have not received a reply, my lord.
Now ESI job's gone also.
Yes.
Your Negrim's job still there.
Negrim job's gone twice, ESI job gone, and I'm nearing 45. I'll place on records, your lordship, the affidavit was filed with only with the one sole purpose,
yes,
that I am not a specialist and there is no cadre of specialist. So in fact, they can release me tomorrow itself if they want. That's what I want to demonstrate before your lordship. Rest I leave to your lordship.
The only thing I can suggest, my lord, at this stage is, if lordship dispose of the matter in view of the subsequent development, with that time frame, maybe 6 months time, make an alternative arrangement and release him.
We'll give you only one thing, Mrs.
Yes, but otherwise he has no right.
You know something? There's a huge shortage of orthopedic surgeons in everywhere you go. So you cannot. It's not a question of you be thrown employment. Even if you resign tomorrow, there'll be 100 hospitals who pick you up like this.
The more
and we know from common knowledge, because orthopedic surgeons are very hard to come by.
Your lordship, but
so that is a consideration, of course, that your job.
That is separate issue. Legally, I can.
But the thing is that it's not a question of.
He wants a legal decision, my lord. I am ready to argue.
Yes.
If they want legal decision only, my lord, I am ready to.
Yes,
argue.
your lordship. I would want either way.
If he wants only a legal decision, my lord, from this honorable court.
Yes.
I am ready to argue, my lord.
Yes, let him argue in that case, your lordship. Your lordship will pass orders either way, your lordship.
Where's the affidavit filed yesterday?
I filed an affidavit, ma'am. It's written. Your lordship, on the last occasions, my respected senior has argued on 3 points. Basically 4 points. The first point he raised is that I
have not concluded my argument.
1 second.
Okay, then you argue.
What have you said here
in this affidavit? In this affidavit, I brought few things. First of all, I brought an affidavit filed by the Ministry of Home Affairs. My wife has called me something urgent. Just talk to her. Go on. This has been filed by the Under Secretary of MHA, wherein they have categorically stated there was another case.
Where's that? Similarly, like your case, where's that?
No. That case was. I'll just present the facts, brief facts of the case. That case related to the GDMO with PG, wherein the GDMO with PG have prayed before this their Assam Rifles that there are other specialist posts throughout India. So you post us there in ITDP, in BSF, in CRPF.
This case, I don't think we can cite it because it's still
pending.
It's still pending.
Exactly. But what I want to say is that in that case, the Undersecretary from the MHA has categorically stated that GDMO with PG are separate from the specialist doctors. They cannot be treated as specialists. First of all,
that's irrelevant, my lord. Simple issue is whether a competent officer is at liberty
what is relevant and what is irrelevant. It is up to the court to decide. Why is jumping and trying to stop me?
My lord, it's very difficult to argue with. Last time he said that he was citing some rules, my lord. He said these are available in the market. That's what he said.
No, I've given him the copy if he wants. I've already supplied.
That's the submission. That's how
let him argue. Why is interrupting
a counsel, my lord.
Why is interrupting
He said
me?
that these books are available
I'm
in
making
the
a
market.
submission as an officer of the court. Why is interrupting me? I don't know. My respected senior will have his chance.
I'll let it to adjourn, my lord. Some other day, my lord.
No, your lordship will either pass the order this way or that way. Keeping in hanging, that shows that he is not interested in getting the matters done. The MHA has clearly stated that we are not interested in keeping a person who is not interested to stay in the force. In spite of them, what is the interest of the Assam Rifles to keep me? I don't understand. There is no legal embargo. In fact, there is no cadre of orthopedic surgeon. I am working as a GDMO with PG.
See, the only thing is that you have to confine yourself to the rules that are governed under
Assam Rifles and Assam. Yes.
And that's whether under the rules. See, you can't compare other cases where they're governed by their own rules.
Yes.
So you confine yourself to the rules you're governed by, and whether within the panel of the rules this option is allowed, number one, and number two, the facts circumstances of the case, which you have to take consideration as what has happened, and then after that the law will follow. That's the only thing. So that you confine your submissions to that. Yes.
Your Lordship, I have already concluded my submissions.
Then we'll pass orders.
Your Lordship, to that extent that the rules does not put any embargo, it does not specifically state that you cannot resign. Of course, there are some exceptions, which exceptions I don't fall under those exceptions. Secondly, they say that there is shortage of orthopedic surgeons. I have categorically demonstrated before your Lordship that there is no cadre of orthopedic surgeons. In fact, I am drawing my salary as a GDMO with specialist, not as a PG, not as a specialist doctors. If your Lordships kindly turn to page 86 of the affidavit.
1 second.
I have filed yesterday.
I'm just going through the reams of papers that you all have generated.
Of course, it got some, with the passage of time, it got some voluminous.
Yes. Brevity is the essence, of any argument also. It's always to the point. Yes. What do you want to show?
I want to show my pay slip, your Lordship.
In your affidavit?
Yes, your Lordship, page 86.
What relevance will it have, your pay slip?
Your Lordship, I am drawing the salary of a GDMO as a general duty medical officer. If your Lordships kindly turn to page 86.
That is a given, because if you join as a specialist, that's a different consideration.
Yes, your Lordship.
If you join as a general duty,
yes, your Lordship.
You go for specialization, even then you're in a separate cadre also.
Right, your Lordship, absolutely right.
But even in terms of transfers and postings,
yes,
of course, they make a distinction with regard to specialists, whether
exactly,
and regard to GMOs.
Right, your Lordship.
Yes.
Now, what I want to show is that if your Lordship looks at page 87, I was at pay level 11, and my basic pay was 80,900. Now, your Lordship will see page 87. After I have completed my PG, I have been granted the same pay, your Lordship. I have not been granted the pay of a specialist.
Right.
So therefore, the Assam Rifles contention that there are 3 requirements of 3 orthopedic surgeon, I am categorically from day one, I am sticking to my arguments that there is no post of orthopedic surgeon.
So now also you think I'm a general duty medical officer?
Yes, your Lordship.
For practical purposes?
Yes, your Lordship. Yes, yes. Okay. Only I am getting a pay increment of PG. But I am not being paid and this has not been disputed or denied by them. The first thing, your Lordship. Second thing is that Assam Rifles is not the authority to make any appointment. It is the MHA. Now, already the Central Board of Police Forces have made the requirement. If your Lordships kindly turn to page 90, B6. Has your Lordship got it?
Yes.
These affidavits, if there is arguing on that, I need to reply to this affidavit, my lord.
That's all right. We just
it's 100 some pages, my lord. I have not sent it to department also. I have no instructions.
Yes. I understand. We understand. I think I don't know. Maybe I don't understand. Maybe I understand. So you're trying to make out a case that you are different from specialists, and so you should be treated as one.
Right.
Whereas your brother colleagues in the other cases are saying that we are specialists, we should be treated as such. So do you think that a finding in this court will have a bearing on other matters?
No. What I want to say is that let me clarify on that issue, Your Lordship.
Yes.
In those cases, the GDMO with PG, who are my brothers in the same forces, they have filed a cases that you please post as a specialist.
Yes.
Wherein the Undersecretary has filed an affidavit categorically denying it and saying that the GDMO with PG are different from specialist.
Exactly.
That's what I'm saying, Your Lordship. No, now the Assam Rifles cannot take another stance to what the MHA has taken the stand. So therefore, my categorical...
One thing, Dr. Muzika, is there's no option for making contractual appointments.
Yes, there is.
In the Assam Rifles.
The difficulty we have written to MHA, my lord,
No, I mean, at the own level, you can't make contractual appointments. The DGA are not vested with enough power or latitude to take such decisions.
That's what I've told me.
They must be having some. Anyway, that's on another point. Mr. Singha will not examine this point because the opening.
It is at page 80. It is at page 80.
Which I don't think this court will go into it.
No, what Your Lordship has just put a question now, that answer is at page 80. In fact, that was also filed by the MHA. Now the entire issue boils down to one thing, because the MHA said that you can release him. In spite of that, the Assam Rifle is not intending to release me. That's the only issue, Your Lordship. Appointment of General Duty Medical Officer and Specialists in CAPFs. In superstitions in the ministries, all past instruction issued by such and such, I am directed to convey the following consolidated terms and conditions of contractual appointment against the vacant post of GDMO and Specialist in CF. The appointment process will be subject to the prior approval of MHA. So they can make, if they release me the post for vacants, they can appoint, Your Lordship. And furthermore, if Your Lordship...
I need to reply to this, my lord. These are 2012 circulars, my lord. I do not know whether they are superseded the fresh circulars or not.
Your Lordship, let him come up with any arguments. I am just making my arguments. My respected senior has every right to counter to that. And thereafter, Your Lordship...
We have lingered this matter long enough.
Yes, Your Lordship.
Usually this court doesn't like to think for too long.
I'll leave it to Your Lordship.
2 hearings, we will generate the judgment.
Your Lordship, I'll not argue thereafter any further. Today is the last day, I'll not argue.
You want some time for to examine the...
If he is referring to any of these documents, my lord, then I'll reply to this. If he is not referring to, yesterday he said he will not refer to this, my lord. Yesterday submission was made that...
On record, Dr. Muzika.
My lord also permits me to... I'll reply to
rejoinder to...
But my lord, bringing in all these peripheral issues, but the core issue is whether a competent soldier, whether he is a specialist or he is a general. That will not make any difference. The right to resign is same for all, my lord.
Whether resignation is a right.
Yes, Your Lordship.
That's the only question.
Yes, Your Lordship.
So bringing in
whether say, Your Lordship, the rules has been read over by me. The rules never say that a person cannot resign after the completion of this. There is nothing in the rules.
Another point with regard to what is appointment and what is engagement.
Get the Assam Rifles.
And also seen another matter is there, my lord. He also wants to resign. So this is why, my lord, these provisions are. Otherwise, what will happen, my lord?
If your lordships kindly, I'm sorry, sir.
Please sit down.
Yes. I was making, actually I didn't complete it. Anyway, reply.
My lord, why these provisions are made, my lord? You also will see, or else what will happen, my lord? In the wartime, all of them will start resigning, my lord.
Give me the judgments.
Or any difficult times, all of them will start resigning, my lord. All the officers, maybe in paramilitary forces, army, my lord. So that's why this right to resignation has been curtailed to a certain extent, my lord. Though not.
Section 8 A and B. I asked what was that.
Let us see. Assam Rifles rules.
Act.
No. Give me. Sorry.
See, it's section 8 A and B, that is in my mind.
My lord.
Regarding no member of force shall be at liberty
to resign his appointment during the term of his engagement.
Now, you say engagement's over, correct?
Yes, sir.
Yes. and B, to withdraw himself from all any of the duties of his appointment,
except with the previous permission in writing of the prescribed authority.
So that we just need an interpretation of these of Section 8, and what was that? The rule is Rule 17.
Rule 27, my lord.
Rule 20, sorry. Rule 27, resignation.
Rule 27 says, my lord.
Yes.
Resignation.
We're not going to go and.
It's in my affidavit, my lordship. Can
I have given the rules, lordship.
Yes. Okay. Now I'll give you two counsels 5 minutes each to argue on this. 27.
So you will argue first or I'll argue?
Aap kijiye, sir.
Then please.
Yes. Instead of going all over the place. See, 27 is resignation.
The central government
and
may.
B is that from the
But it says, my lord.
Yes, 27 says.
The central government may.
27, 3.
I'll read one more first.
I'll read one.
The central government may, having regard to the special circumstances of any case, my lord, there's a proviso to this inbuilt mechanism in that, my lord, permit any officer of the force to resign from the force before completing the term of engagement.
Yes.
Special circumstances of each case, my lord, the central government will consider and pass an order. Here, my lord, original case setup is that he has been appointed in negrims. So the government took a decision on the basis of that, my lord. During the pendency, he got another appointment, my lord. Then he says that now I want to resign because of ESIC. During the pendency, because we have to examine special circumstances of any case, my lord.
No, special circumstances is this. You have to
For resigning.
No, why he wants to resign is because he is a commander now, right? In the Assam Rifles. He is prepared to resign to go as a senior resident in some other military because of the necessity to look after his parents. That's it. That's a special circumstance.
Well, parents are not in Shillong, my lord. Parents, I do not know.
That is why
I don't want to.
They're in Shillong. That's why he wants to, be because now he put in Sukhovi.
Yes,
Where are you?
Nagaland.
Yeah.
I stay in the quarter. I cannot take my family there, your lordship.
Yes, yes.
So
that's a consideration.
So that
special circumstances.
A solution to that can be, my lord.
This officer or doctor, he wants to resign from engagement because he has other compelling circumstances, family. He wants to, and those are circumstances all. So whether he goes to Negrims, ESI, or he starts his private clinic, that'll be immaterial, I think, to the yes.
My lord, that will be immaterial for us. But my lord, what it says. 2, my lord, the central government may accept the resignation under sub-rule 1 with so not relevant. My lord. 3, the central government may refuse to permit an officer to resign if an emergency has been declared is not applicable.
You only have recourse to 3B.
Inexpedient to do so in the interest of discipline of the force, my lord. And that's the most vital aspect, my lord. Because if we permit one resignation, my lord, the second resignation is already on board, my lord.
That is only, the whole thing boils down to this, not going here and there. Now, whether these rules vest upon him and you apply general law now whether resignation is a right of an employee.
Well, I cited Supreme Court decision, very recent decision by Justice Chandrachud, my lord, which says that this central service, civil service rules and the general law, labor law will not apply to paramilitary forces. And it also says, my lord, that resignation is not at the sweet will of the employee in armed forces.
So another question is that now, if you consider it now as it stands, whether you suppose you take it to be his right, then he has a right. Right is there, but whether that
subject to acceptance,
unconditional, that's different. Now your rules prescribe certain preconditions.
It's a bilateral act.
It's bilateral, and so now, can you keep his resignation in abeyance after you've come to a finding that it is not? We do not want to keep an unwilling officer in the force. You don't want to keep him now.
We are not saying that it is undesirable. Government does not.
If that is a thing, though, whether it's right to keep.
But the letter says that it is not in the interest of the government to keep an unwilling person, my lord.
Exactly.
That's the exact wording, my lord, of the letter.
Then.
But maybe such kind of people will start doing anything, my lord, in OT also.
No, not start doing anything OT doesn't mean that he'll go breaking bones, something. No. But It's not. It's just that. It's just that we just on this very narrow point. We don't want to go with all these compilations and judgments they've given.
But that's why on my insistence,
So
my
the
lord,
only thing is that you say that it is not expedient in the interest of the force to grant him resignation. Finish. That's the argument.
At this time, my lord.
Yes. Now you start. Why is it expedient that you be given this?
But in any case, to resolve the matter, my lord, in terms of the ministry, I am proposing, my lord, your lordship dispose of the matter. We are giving 6 months time that you make an alternative arrangement, releasing within 6 months. That direction can be passed, my lord. That's a kind of concession from the department.
I think we'll pass a one-page judgment.
Your lordship, I'll just.
So you understand the confines of your argument, right? You do not go here and there, GDMO and specialists and
27.
Yes, 27.
That's for sure.
And 8A. Yes.
The central government may, having regard to the special circumstances of any case, permit any officer of the force to resign from the force before completing the term of the engagement. So this has to be understood in terms of the engagement for the period, initial period for which I have engaged, wherein I cannot move out.
According to the term of employment.
Exactly, your lordship. If that would not have been the case, then why they would have asked me to sign a bond?
Yes.
Therefore, resignation is very much in the teeth of the act. It's a right of the employee. Your lordship will understand one thing. Your lordship will make note of one thing, that there is two things in the service: voluntary retirement and resignation. Voluntary retirement is a condition of service.
No, that's different.
Yes.
The retirement is only up to them whether it will be allowed.
But
resignation, you have to say,
is a right.
You have to show the right. Yes. Show how is the right.
It's implied.
Yes. How is it implied?
I'll just show. I'll just read one. Your lordship need not trouble it. Your lordship will just. I'll read it.
Yes.
In view of the aforesaid enunciation of law and on the consideration of the provisions contained and the circumstances of the case, we are of the opinion that the appellant has rightly terminated the relationship of the serving the requisite notice for resignation. To resign is a right of the employee who cannot be forced to serve in a case he is not willing until and unless there is some stipulation in the rules to stop him. So
Exactly.
it's a right. The moment I join the
stipulation is there in the rules.
Yes. So stipulation during the period of engagement and provided there is some disciplinary proceeding against me. Your lordship will kindly mark.
No, that is different. You're referring to the Calcutta judgment.
I'm referring to Sanjay Jain, 2019 for SCC.
See, that is different. We are not talking about other rules. Forget CCS rules, forget other rules governing any other service. We are just confined, please confine yourself to this. Whether there is anything that they can stop. Now Dr. Mozika says that he stands squarely behind 3B.
3B.
Yes.
I would say.
Now, how do you argue around this?
Your lordship, 3A, 3B, 3C does not stand in my case.
Okay, why? Okay, first 3A. No emergency. Okay, B.
There is no emergency. If it consider it is inexpedient to do so in the interest of the discipline of the force. Now, what is the cause? The one thing, if your lordship remembers, from day one, my respected senior is arguing that we are shortage of orthopedic surgeon, which I have clearly demonstrated before your lordship. There is no cadre of orthopedic surgeon. How can you keep me? It is only GDMO with PG. There are several others in the list, and it is the MHA who is the appropriate authority to appoint. They will appoint it. The Supreme Court has categorically stated you cannot bind somebody, even during the period of bond, if some emergency arises for that person, and I have completed the bond. So what is the use of keeping me when I have already stated that there are compelling reasons? Of course, I have served this force. I have utmost respect for it. I have earned my livelihood. I have spent some considerable years of my life. But now I have some other duties to perform as a son of the family.
That's it. Finished.
Yes, your lordship. Yeah. And the law.
Not only one thing, my concession was only if it is an amicable settlement of the issue, my lord.
Let me think about it.
I object to that. Your lordship will pass either way.
Regarding?
My lord, this 6 months is proposed on the basis they accept it, my lord. If they are not accepting it, my lord, then I'll request your lordship to kindly pass on law, my lord.
Yes. I am not objecting to that.
Yes.
If he is not accepting that 6 months proposal,
I have made my arguments. Your lordship will consider arguments, but the middle way path, I am not accepting that.
17.
And your lordship, on the last occasion, query fell from your lordship whether the CCS rules applies or not. CCS rules applies, your lordship. Why I am saying so? There was a question raised in the parliament. As an officer of the court, I am making that submission. A question was raised in the, I'll just...
Matrimonial dispute.
No, not matrimonial dispute. A question was raised in the parliament that, if your lordships kindly see. Yes, sir. Sir. There was a question, if your lordships kindly look at the second page, C and D. According to the Act of various forces under the Ministry, BSF, CRPF, CSF, such and such, Assam Rifles has been constituted as armed forces. The service and the condition of CAPS personnel and defence personnel are governed by different set of rules. The CAPS persons are entitled to in-service and post-retirement benefits as provided in CCS Pensions Rules 1972 and cannot avail these benefits at par with a defence personnel. So it applies to us.
Where are you reading?
Your Lordship, page 2.
Reply by whom?
It's applied upon Assam Rifles, Your Lordship. There was a query raised in the parliament whether the CCS rules applied upon the CIPF, Central Armed Police Forces, that is CRPF, CSF. Wherein the answer was made by
the retirement and post-retirement.
Pension matter.
So,
Pension
ultimately covers, Your Lordship. That's a thing. I'm deeply obliged for giving a patient hearing.
17.
Obliged.
Yes. Mediation.
No, Your Lordship. Mediation.
Yes,
my Lord. Service matter, my Lord.
Why do you agree last time? Oh, not agreeable.
Not agreeable. Matter was supposed to be taken today, Your Lord, my Lord, as a fixed matter. So we anticipated that my friend would be.
Please, Your Lordship, we may be allowed to file the amendment to the petition, Your Lordship.
Amendment at this stage?
Yes, Your Lordship.
Cause of action arose when? You are impugned with you agree with which order? Which one? MS Bala, which one?
2022.
Resolution dated 2012-22.
2022, my Lord.
How can allow you amend the petition now?
Lordship, on the last occasion they came up with the confirmation order.
With the?
Confirmation of appointment.
We filed an affidavit, my Lord, respondent number 9, whereby we place certain
We
document on
can't stop you from putting an application for amendment, but whether the court allows you, that's a different question. So you can file an application and we'll consider it. If they object to it, then we'll have to hear it first on the amendment, on whether the application will be allowed or not. Okay?
Sure.
Yes, MS Ibla today praised that due to certain developments, we will be allowed to file an application seeking amendment petition. Ordinarily,
1 week time may be allowed.
1 week time is granted to file the application. Whether we allow it is different. Yeah, because they will be allowed to file the objections also.
18.
That's not a matter of plea, you know?
Yes, sir.
That's the thing, you have to remember that. Yes.
Hello, Blake.
Yes.
Yes.
Yes. These are two matters together. Only one case.
Only one matter.
Yes. Please start.
Your Lordship, before I proceed, I would just like to point out, Your Lordship, that there are pleading applicants also, Your Lordship, whose application is yet to be considered by this court.
Who are in
This
plead
is number
applicants?
50 of 2024.
I am, Your Lordship.
Who are you?
I'm the.
This Krangsuri?
No, the Thlumui.
This is right Amwi, Your Lordship. Ramsuri is right one.
The matter relates to Thlumui, Your Lordship, where they have for offering of prayers.
Rajwam is not near Nong Talang, no?
No, Your Lordship.
It's adjacent to the Raj, Your Lordship.
Rajwam
So, Lordship,
and Raj Amwi, they are adjacent to each other.
I must case. This is Kerlang Tariang.
Yes, Your Lordship.
You are Kerlang Tariang.
Yes.
So you change the name to Kerlang Lingdo or Kerlang Tariang now?
Kerlang Tariang.
Yes. You file, you object his impleadment. Why?
Yes, Your
Who is he?
Your Lordship, because our prayer in the writ petition is very limited, Your Lordship. We are saying that we are the believer of the Nyam Shno, which is like the Nyam Khasi, Nyam Tre, Your Lordship. So we want to conduct prayers anytime there is any project.
So why are you objecting to his impleadment?
Your Lordship, because they are saying that they are the Lingor. They are claiming to be the Lingor who is supposed to be conducting the prayer. We are saying that he is not the Lingor. In fact, the post of Lingor till date is disputed, Your Honor.
Yes.
What has happened here was that prior to the institution of the writ petition, we had filed a suit before the district council stating that we are the Lingor. They had filed a suit before the KDC Anaram stating that they are the Lingor. So the post of the Lingor till date is disputed. But however, Your Lordship, before this, we have not come for that concerning the course or the administration of the right. Our prayer here in the writ petition is.
So see, the thing is that MS Dongri, impleading him, what impact will it have on the?
Your Lordship, actually, we don't have any objection if they in fact join us in the prayer. The thing is that they are obstructing us. That is the objection that we have.
Why obstructing, Mr. Lingdo? Is he obstructing them?
No, Your Lordship. But the matter of controversy here and have plead because I'm the Lingdo. As you have stated that a suit
That's
was
your
filed.
assertion only. She doesn't accept that.
But Your Lordship, let me clarify on that. As of at present, Your Lordship, the entire matter related to the Lingdo of Rajamwi is pending before the JHDC for consideration. So, Your Lordship, on that grounds, if the matter is decided by the JHDC, then
because evidence has to be taken as who's Lingdo. That cause will have to be taken. Only what is the prayer you want now in the petition?
This prayer is with regard to the implementation of the Jal Jeevan scheme. Per se, Your Lordship, we don't have any objection.
Where's Lingdo? Where's Jal Jeevan scheme now?
Your Lordship, I'll come to that. What happened here is that the scheme is being implemented from Thlu Movie. That Thlu Movie Falls, Your Lordship. Thlu Movie Falls is considered to be a very sacred site by the writ petitioners here. So, Your Lordship, before any implementation, before any project is implemented, what they want is that their right and their religious sentiment should be respected, Your Lordship, before that project is being undertaken.
But they're allowed to offer prayers there now. There's no,
yes, Your Lordship, they were allowed. In fact, the government has filed the affidavit stating that they have no objection.
Then?
But in the meanwhile, Your Lordship, they are filing, Mr. Lingdo and his parties, they are filing this impleading application, Your Lordship.
So you withdraw impleading application?
No,
in fact, Your Lordship, if they want to join us also in the prayer, we don't have any objection. Concerning those dispute that we have in other cases also, Your Lordship, we are offering
See,
them.
the only thing that, if we understand correctly, is that you're at different ends in the district council, different sites, sorry.
Yes.
Right?
Yes, Your Lordship.
Then you take a dispute there. In whose court is it pending?
Your Lordship, actually, with matter to Lingdo, there's a dispute. Well, the entire proceeding before Your Lordship is the offering of prayers.
See,
I'm pleading myself.
What is there? Who's appealing for the government? We'll close it, yes. You file affidavit.
Yes, Your Lordship, they have filed stating they have no objection.
Where is that?
Your Lordship, moreover, Your Lordship, the prayer which they have sought for relief from the court has already been performed. Your Lordship, I have brought on record, Your Lordship, I have filed a miscase.
Yes, Your Lordship.
Completed, how do you file a miscase?
Yes,
We
Your
not even
Lordship,
pleaded
that also
also.
I want to raise that objection.
She did not raise objection all the while, Your Lordship, on that. But I have brought on record that it's already been performed. On 24th.
Why done and pleaded also you file your objection?
Yes, Your Lordship, they have never got the opportunity to raise this objection. They have never been impleaded. They filed the affidavit, Your Lordship. And this affidavit filed by them is with regard to harvest, Your Lordship. Prayer for harvesting, not prayer for the implementation of the project. They are trying to mislead the court.
Lordship, she's misleading the court as well with the matter related to the Lingdo.
This is with regard to harvest.
The suit that they have filed, it's already been disposed
I have
of.
mentioned in the writ petition, different kind of prayers are being offered.
There's no suit pending now.
Yes, Your Lordship, there is one suit pending at Amaram Civil Subdivision in which they are saying they are the administrator. Regarding my suit, that has been dismissed, Your Lordship, by District Council Court on the ground that it does not have the jurisdiction. So, in fact, Mr. Lingdo, just now he mentioned that the case is pending before JHDC. This is the first time I'm aware of that case. We have not been issued notice concerning that case.
Yes.
The petitioners are the one filing objection, Your Lordship, before JHDC.
I'm not aware of that, Your Lordship.
Yes, what is some?
Lordship, the petitioner here, they have filed an objection against me as a Lingdor. Because the Doloi
Executive Committee.
Yes, Your Lordship. So let the matter ends there, like with respect to the matter and controversy to the post of Lingdor.
Yes. Where's the affidavit filed by the state?
Your Lordship, this is
Right on 23rd of February, Your Lordship.
2024, Your Lordship, last year.
Yes. File for statement. Which case can the main case there?
Your Lordship, we've stated that we have not prevented them from performing their
No, Your
rituals,
Lordship,
Your
it's not
Lordship.
about prevention. It's because prior to filing the writ, we had filed a representation for the government, Your Lordship. They were silent. That's why we were compelled to file a writ petition. It's not about prevention, Your Lordship. It's about respecting the religious sentiments and freedom of the writ petitioners.
But doesn't mean that your offering prayers will disrupt the implementation of the project.
It is, Your Lordship.
You're disrupting the implementation project.
It is from the side, Your Lordship.
What?
No, we are not preventing, Your Lordship. Per se, we have no objection towards any development
That's
in
fine
that
then.
area. In the pleading also, we have clearly stated, Your Lordship.
Yes. Take down. The writ petitioners who are stated to be the members of the Raj Amvi AMWI on being authorized by other members of the Raj are before this court with a prayer that the petitioners and other members professing the Nyamshnang
Nyamshtong, Your Lordship. Yes.
Nyamshnang be allowed to offer prayers at their secret religious site, that is the Thlu movie THLU MWI river located at is West or East Janta Hills?
West Janta.
West Janta Hills. Meghalaya. Stop. The petitioners, it appears, as per the submissions of MS PS Nongbri, learned counsel for the petitioners, have been prevented from carrying out the rituals as in the set site itself, SITE itself. The PHE department of Amiram Civil Subdivision will be implementing the Jal Jeevan mission scheme for water supply. Stop. That council has submitted that the source of the water for this scheme is from Thlu itself. Stop. And that she has been compelled to approach this court inasmuch as on being prevented by respondent number 5 from offering prayers, respondent number 5, yes, from offering prayers, though representations had been filed, the same were not addressed or attended to. Next by MSZE non-country Leonard GA appearing for the response 125
Yes, Your Lordship.
has referred to her affidavit and has submitted that there is no
The apprehension is misplaced, Your Lordship, because we have not prevented them.
expressed by the writ petitioners is misplaced, inasmuch as there is no restriction on the petitioners or members of the Raj offering the praise, as long as the same does not in any way disrupt the implementation of the project. Stop. She therefore submits there is nothing left for consideration in the instant writ petition, and the same may be disposed. There's no restriction. You offered prayers last time, correct?
Way back.
You know, recently you did not do it.
This, Your Lordship, not for this purpose. Last time we offered prayer for it was for harvesting, Your Lordship.
No, I mean, but now there's no restrictions, correct?
Now there is no restriction.
Your Lordship, here many
The
water supply
undertaking-
schemes have also been implemented, and they've never been prevented, even
Yes,
in the past, Your
The
Lordship.
question is not about prevention. The
No,
government does
you
not
just
own
okay.
that
This is the
land
order.
other than
Yes.
us.
Before disposal. You can for and as much as the scheme has since been implemented, and such a case matter is disposed of. Next paragraph. MSPS Nongri, however, has raised another issue and submitted that the situation submits that even in the Raj Amvi itself there is a dispute as who to be the rightful lingdo.
The administration. as a whole.
Yes.
Administration of the Raj.
The absolute Raj of lingdo is under dispute, and that the same is also pending adjudication before a civil court. Stop. She submits that in these circumstances, as there's undertaking given by the state respondents that there shall be no restriction, the repression can be closed. The subscription can be closed down. Next paragraph. On hearing learned counsels and the submissions, and also on the fact that the state respondent on affidavit have undertaken that there's no restriction, the main prayer in the writ petition therefore does not survive for consideration, and the writ petitions are accordingly closed on this point here. Now we'll come to whether miscase. Miscase, impleadment, correct?
Number 50.
Yes. Miscase number 15? No.
Miscase number 50.
50. Yes. Miscase number 51. Stop. In the course of WPC, it's number 400 for WPC. In the
Yes,
course
sir.
of the proceedings of WPC number 400 of 2023, one Shri Kerlang Lingdo.
Kerlang Tarek. It's clerical error in there.
One Kerlang Tariang has filed instant business application for impleadment as necessary party. On party which has been objected to by the petitioner. Stop. A perusal of the application for impleadment reflects that the applicant has sought to bring on record the fact that the control, management and administration of Raj Ummi is presently under adjudication before a civil court of competent jurisdiction with regard as to who, this is regards to who should be the.
Your Lordship, the matter pertaining to Lingdo has already been disposed of.
No.
Now remains is the administration of the entire
Your
management and
Lordship,
administration.
Even in their suit, they are claiming that they are the Lindo.
Okay, fine. Before Amrarem also.
This is before Amaram, and just a while back, Mr. Lindo said that even before district council, it's been.
Yes, so fine. No, matter. That the matter relating to the control, management and administration of Raj Ummi is under dispute and is being adjudicated before the Court of Competent Jurisdiction at Amrarem. Stop. You filed a statement there.
Your Lordship, I'm filing an application for rejection of the claim because that court does not have.
You are filing or you filed?
I've already filed. It's fixed relief.
Yes. This for adjudication. In the title suit being TS number 2 of 2021. Stop. This fact has been noted by this court, and the same is also not disputed by the learned counsel for the writ petitioner, who further submits that an earlier suit with regard to the same subject matter had been filed before the Sovereign Council Court, which has since been dismissed for want of jurisdiction. He further submits that with the matter regarding Lingdo, the same is also pending for executive committee.
Your Lordship, it's before the Alaka JHDC. President.
Doloi.
No, Your Lordship,
No, Your Lordship, Ilaka.
Yam in charge Ilaka.
Yam in charge
There's no
Ilaka.
report anything. It is stop. Next paragraph. As the main petition has since been disposed of, the instant business application for impleadment also does not warrant any further orders, except that the main matter, that is the except that whatever dispute that remains, particularly regarding the management and control, management and administration of Raj Ummi, be agitated before the said court where the title suit is pending.
Lordship, it's my humble prayer that barring the title suits, Your Lordship, we may be allowed to conduct. They may be restrained from
conduct their prayers.
Prayers, yes. Not only for this, but for other prayers also, because.
So we'll not agitate.
There are no restrictions. There are no restrictions. If anything, you come back. Yes.
It's just a small prayer.
We'll correct that order. Yes. Accordingly, in this case also stands this process. In the main case, then we'll add the main case. Yes.
Authorised, Your Lordship. 21.
Yes.
The matter has already been heard, Your Lordship, except if some instruction the respondent had to acquire from the respondent office.
Already, Your Lordship, on last occasion, I have provided instructions also. But, it is not possible for the present, Your Lordship. There is no vacancy, and moreover, the where petitioner was a. Yes, Your Lordship.
Then if the letter dated 26 May 2025, Your Lordship, which we have If you look at the matter or the letter, Your Lordship, they have stated, in fact, undertake, Your Lordship, that if there is any vacancy
Yes.
arises in the future,
Yes, in future, yes.
that
Record
may
that.
be added in the order. Your
Yes,
Lordship.
sir.
That may be.
Yes, okay.
That will suffice.
When did you join?
2001, Your Lordship.
You're not working now, no?
He's not working, he's not doing anything. He's 47 years of age.
47 years of age.
Then you can.
Yes. The writ petitioner. Since 2001 you were appointed.
23 years of service. Your Lordship.
But Your Lordship, intermittently, Your Lordship, 2 years, 1 year, 59 days, with a break in service, Your
The
Lordship.
petitioner.
And it is for a particular project, Your Lordship. That project.
The petitioner being aggrieved with the termination of his. There's a termination letter.
It's at,
15, page 15.
Speech 21, Your Lordship. Speech 21.
Being aggrieved with the order of terminating his services, terminating of his services as multitasking assistant on contract basis in the project management unit of Swachh Bharat Mission. With effect from termination, no, with effect from so and so. Emotions matter on number 3. Emotion after issued by the issued by respondent number 3. With effect from 2nd December is for this court. With a prayer that having served for 23 years in the office of the respondent is eligible to considered to a permanent post of typist. Stop. Next paragraph. MS Bisun, the counsel petitioner, submitted that the writ petitioner was appointed to officiate the typist initially on 19 February 2021 and thereafter was allowed to continue.
2001, Your Lordship, may I please alert? Initial appointment was in 2001.
2001? That's what he said. What is he saying?
But Your Lordship, I heard 2021.
I said 21?
Yes.
Oh, sorry, 2001. 2001. And was continued to officiate in the said post.
But in 2007 also, Your Lordship, there was a he
Yes.
was terminated.
The termination letter was issued every month.
Yes. Was not continued to post, though intermittently was terminated and was allowed to continue thereafter. Stop. Learned Counsel has drawn the attention of this court to the series of office orders from 2007 onwards to
2015.
to no last as thing as a typist were 2015 when he was allowed to officiate as typist. Stop. Thereafter she submits by office order dated 8 February 2017. The writ petitioner was appointed on a contract basis as a data entry operator.
But Your Lordship, in the meantime, in 2017, there was an agreement made with the respondent number 3 that it is a contractual appointment.
No, of course, we're recording that. Why is interrupting? That's a submit upon contract basis data entry operator in the office of the project director SIP MIU Shillong on a fixed pay of 20,000. In this contractual agreement, in this contract and agreement, as was also executed between the writ petitioner and the said project director, whereby it has been categorically given therein that the said appointment would vest no right in the writ petitioner to claim prioritization. The said appointment was again renewed
It was renewed, Your Lordship.
for only February to June.
February 2018 was the last appointment.
Yes, it was renewed up to 30th June 2018, whereafter she submits by another office order dated 3/11/2023. The writ petitioner was appointed in the current post from which he was terminated permanently. Yes, he submits that the writ petitioner had then preferred a representation for the respondents to consider retaining him in his service on account of his long years of service, but the same received no reply. So, therefore, prays for some consideration. She prays that she therefore prays that the respondent be directed to give due consideration and to accommodate the writ petitioner in a suitable post. Stop. As per Saji Learned Counsel for the Learned GA has submitted that as submitted by the Learned Counsel and from the records itself, the petitioner was all along appointed in officiating or on a contractual basis, and on the last appointment was attached to a scheme which on the conclusion thereof the writ petitioner was terminated. So he submits that the writ petitioner has not acquired any right to claim privatization in spite of the long years of service, as he was never appointed against a regular or sanctioned vacancy, but was always appointed against officiating on an officiating basis or on contract against said schemes. Our Learned Counsel for the parties on the earlier date of hearing, when the matter had been taken up for consideration by this court. Instructions by this court on 8/5/2025 by the order. By this court, on 8/5/2025. Sorry. by order dated on earlier date on earlier occasions when the matter was taken up consideration of this court by order dated 28/3/2025, this court had observed that the engagement with petitioner being really temporary and contractual, no mandamus could issue to direct the respondents to consider for permanent absorption or employment. But taking consideration the long years of service, and as the writ petition was a mercy petition, this court had directed the respondents to examine as to whether the writ petitioner can be accorded any sort of contractual appointment in view of his acute financial crisis. Thereafter, by a communication dated 26 May 2025, the learned government advocate, thereafter, the learned government advocate on instructions had produced a communication dated 26 May 2025, wherein it indicated that presently there was no post of typist lying vacant in the department. To accommodate the writ petitioner, but however, they may consider his case for engagement of in temporary or contractual post if any vacancy arose in the future. Next, as earlier observed, without dwelling any further on the facts, as earlier observed, the petitioner not having acquired an vested right to permanent absorption in any post in the department, is however directed that the respondents shall positively consider his engagement in contractual or temporary basis against any scheme or any vacancy that may arise within the period of
6 months.
6 months from today. Yes. Sorry, can't help you. With our directions, matter stands dispose of it.
23.
Please, Your Lordship. Lordship, this is the Samsaric matter wherein the petitioners were ostracized from their village and the house were destroyed. Here, what has happened, my lord?
I think, I'm a bit short of secretaries. I think we'll have to. What? You want to close the matter? Is it on a short compass, or you want to hear the time? No. I mean, is it short?
Before my friend submits,
yes,
I have instructions that the FIR is culminated into a charge sheet.
Oh, where's that?
It has already been filed, my lord. I just received instructions. I have copies of the summons that have been issued to.
Now, where's your prayer?
Their prayer was for arrest of those private respondents.
Now, charge sheet been filed against whom? Against the private respondents?
Private respondents, 6 to...
The charge sheet been filed against them?
4, 5, 6. Now, against whom it has been filed?
Before when the matter is taken up, Mr. K.C. Gautam, legal counsel for private respondents, submits that the private respondent has since been charge sheeted. Stop. Mr. A.G. Movement, praise will not obtain instructions.
We'll also obtain instructions. We'll also obtain instructions on this matter.
Learned EAG also to obtain instructions in this regard.
24.
Hello.
Oblige, Your Lordship. Yes, ma'am.
Yeah, please, Your Lordship. On the last occasion, my lord, the respondent were directed to produce the record of 187 Executive Council meeting.
What was the 187 Executive Council meeting?
Yes, my lord. Lordship, this is the case, my lord. There was a criminal case, harassment. The criminal case was compounded. My lord, after that, my lord, he retired, but Executive Council took a decision, my lord, that period spent on suspension, my lord, will not be treated on duty under the facts and circumstances. So there is a reference of a legal opinion. So, my lord, on the last occasion, Lordship wanted to see that records. I have it, Your Lordship. These are the two, no? Where is the opinion? Where is the opinion?
Don't have a look at it also. Your name? Here?
Opinion.
Rashid.
Legal opinion way.
May I have a copy?
This is the second. This is the first.
Legal opinion way. This is not legal opinion. Yes. Well, there are two opinions, Your Lordships.
Cool.
This is a matter of records. I am not serving a copy, my lords. This.
May I see that?
One second.
Without a copy, how can I submit it?
You do that.
Because the impugn order was they have just written that legal officer by letter order so and so has submitted the comment. The comment of the legal officer was read out before the council. The council deliberated on the matter. The council resolved to regard the request of the petitioner. This only matter. So what was the legal opinion? So it was not informed to us. As on date, and my lord, the main thing is that, my lord, in the trial court has compounded the petitioner, and the subsequently the departmental proceeding was also closed, my lord. So this is subsequent to the departmental proceeding, my lord. This order was passed, my lord. The petitioner was just claiming his benefits, my lord. The retirement was subsequent, my lord. But prior to retirement, my lord, he was reinstated, my lord. And he was joined the duty, my lord.
Okay. See, the legal opinion says this. Legal position in such cases is that when a government servant who was placed on suspension on contemplation of departmental proceeding, stroke criminal proceeding, and after conclusion of such trial proceeding is acquitted, not on technical ground, but on merit or fully exonerated, then the period of suspension can be termed as wholly unjustified, and the government servant shall be paid the full pay and allowances to which he would have been entitled, had he not been suspended. However, in this case, as both the criminal trial as well as the departmental proceeding has not been completed against Professor so-and-so, this has rendered him impossible to get himself fully exonerated from the charges leveled against him. Further, since he has not submitted the documents that requested university, the officer proceeded this case and placed the matter before the Executive Council or examined so-and-so. So in view of so-and-so, the matter is placed as the council And so that is what happened. And this is a very long one. See.
Other opinion, basically, my lord, the legal officer has relied on the FRS.
To treat the period suspension, yes. So, Rule 54B, FRB, when it comes to who has been suspended is competent organization shall not make no so regarding pay. Yes. They are available to RTI.
Lordship.
They are available by RTI. Can you apply for them?
He can, my lord, otherwise, my lord has read out the entire thing. This is the basic contentions. Yeah.
So, very long note. Let him read it.
A copy may be served, my lord. So.
This is a matter of record. This legal opinion, my lord, we are not supposed to, my lord, punish.
Then otherwise, my lord, then the MP notary is not explanatory, my lord, self-explanatory.
Yes, but see, the thing is that why records are examined by the courts all the time. Records are examined because maybe the impugn order might be very cryptic, but the decision-making process has to be examined.
Yes.
And so, the process that is fine, then, you know, whether under judicial review, that's what we can examine. We can examine the records. So that's the view.
We cannot record. I am facing difficulties.
You'll find difficulty, I understand.
Because it's a long one, so what is written there, I don't know that. Even it was not also informed to the petitioner, my lord. So I have no instruction to that extent also, my lord.
Regarding whether he supplied any materials or not.
Yes, yes.
It's recorded there. No.
My lord, otherwise, my lord, since the petitioner was compounded, my lord, and it amounts to acquittal, my lord.
There is such thing as, you know.
And the departmental proceeding was also stopped by the.
You have to argue that point now. You know the reason you argue in that point next date, that compounding or non-exoneration or not being discharged, acquitted honorably will, you know, honorably will. Where is that impugn order? Page?
Page relevant portion 52, my lord.
52?
Yes, my lord.
That's all.
This is on.
Yeah, I think let him read it.
These are all low points, nothing else. Facts, there is no facts.
He can read it.
This is legal knowledge.
You take the thing, you read it, and then you return it to MS EPLA. You read the points. Then you can make arguments along those lines. Okay. Yes, a copy of the records.
Copy of the records, my entire records. No.
No, these are
legal opinion.
One. That one you showed. This one you showed me. That's the only one you have.
This is the one. I'll give him a copy. No problem. Yes. Only thing, my lord, he'll read the legal opinion.
He'll read it. Yes. The records, as directed by order dated 15/7/2025, of the proceedings of the 187th EC meetings has been produced by Leonard, SN Leonard's counsel for the respondency. The same are perused. He has noted that the same are voluminous. The counsel, Mr. Rashid, will please be allowed to examine the same to make notes for his arguments. The same is allowed. You make notes in the course of the day. Yes. You examine them now. You're from Guwahati?
Yes, ma'am.
Otherwise, you want, I'm not, see, record not supposed to give, you want to give him a copy, he can photocopy it. It's up to, this off the record.
Otherwise also has no problem, my lord.
Because you can just photo them with your phone. Yes. There's nothing there, yes. Give it.